Did you get the invite?
No, not yet. That's one thing. If you can send them out and you send them out to everybody else, would be nice. But this way, I don't have to wait for it because we want to send it again. Can you just read off the notes?
Did you get the invite?
And you will before we do.
Right.
Good morning.
Good morning. Or yes, good morning.
I'm calling civil appeal number 5 of 2020 in the Court of Appeal, Civil's jurisdiction. Credit Suisse Life Bermuda Limited against Bidzina, Ivanishvili, and others. On behalf of the appellant, I have Mr. Stephen Moverley Smith, QC, being instructed by local counsel of Appleby Limited, Mr. John Wasty, Ms. Hannah Tildesley, and Mr. Sam Riihiluoma. And for the respondents, I have Mr. Charles Hollander, QC, being instructed by local counsel Hurrion and Associates, Ms. Sarah Jane Hurrion, and Ms. Judith Roche for the respondents. This appeal is before my Lord President, Sir Christopher Clark, and Justices of Appeal, Belly and Dame Elizabeth Gloucester.
Well, I can't see Mr. Hollander.
His name is there. His microphone is muted. Perhaps if he unmuted for a moment, we might see him.
Are you there, Mr. Hollander?
His mic is muted. Let me unmute him.
Are we not going to see him? I mean,
Mr. Hollander, can you hear me?
he doesn't to be able to hear us, and we can't see or hear him.
Also, you see the number.
Is there any way that the counsel instructing Mr. Hollander from Bermuda can raise him by phone?
His Hurrion is muted.
Oh, that's better.
Say that again, Ms. Hurrion.
Good morning, my lords. Mr. Hollander says he can see and hear everybody, but for some reason at this point, we can't see him or hear him.
He has unmuted him.
If you can hear us, see if you can catch.
It might be an idea if he tried to log in again. That sometimes clears it.
connecting to audio.
Good morning, Mr. Hollander. Your mic is muted. Can you hear me, Mr. Hollander? Okay. Mr. Hollander, if you can hear me, in the invitation that was sent to you, there are dial-in numbers. If you can dial one of those numbers to get into the meeting so that we could hear you, that would be helpful. My Lord President, I think you're saying something, but I can't hear you.
Christopher, we can't
Yes.
hear you.
Can you hear me now?
Yes.
Yes.
Yes, I'm sorry, my machine did its usual. Where are we in chasing Mr. Hollander?
I've just asked him to try to dial in with one of the numbers that appear in the invitation.
Right.
Who is the number 244 at the bottom?
I believe that's Appleby.
And is there a transcript writer?
No, there is no transcript writer here. Does the panel wish to retire briefly while we sort Mr. Hollander out?
That would work.
Well, briefly, yes.
Okay,
But as soon as you have, contact us, please.
all righty. Okay. Miss Hurrion.
Mr. Quello, I've just spoken to Mr. Hollander. He's having trouble with his microphone. He's going to telephone in now to see if he can join by telephone. He can see everybody and he can hear everything, but for some reason he can't make his video or audio work.
Is he dialing from a laptop or a mobile phone?
He's in chambers and he has two screens on a desktop, as I understand it.
Yeah.
But he's going to dial in from a phone.
One of the inquiries is, does he have a microphone attached to his desktop?
My lord, I don't know. I'll make inquiries.
Okay.
can you hear me? Mr. Coelho?
I hear you, Mr. Hollander. Can you hear me?
Yes, I can hear you. So can I tell you the position? I'm sorry about this. I've done previous calls from my home computers without any problem at all. I've gone into Chambers because I've got bigger and better screens there, and that seems to be causing the problem. It says something about your microphone not being connected. I've no idea, but I can hear everything and see the court, but they
Okay.
can't see and hear me.
Right. Well, I can hear you perfectly now by this means. So are you happy to proceed this way?
Yes, I mean, one possibility is that given that I'm assuming Mr. Moverley Smith's going to make his submissions first, it might be that before I make my submissions, I actually go home and go back to my home computers. But should we just see how we go?
Do you have on-site IDT support?
Not on. There's nobody here in the building at the moment.
Ah, okay. All right. I'm quite happy to have you proceed in this way as long as you can hear and see us, and we can certainly hear you.
Yep. Okay. I'm happy with that.
We'll be deprived without seeing you, but I don't think that's completely fatal to the appeal proceeding.
Right.
Mr. Hollander, I will send you an email with my cell phone number.
Yes, that's fine.
In case you
Thank you
lose
very much.
and you need to immediately get in contact with me, you can do so that way.
Thank you.
All right, I'll have the judges come back in now.
Right. Oh no, oh no.
Justice Gloucester is not with us just
Oh
yet.
no. Right. Mr. Hollander, I gather that you can hear us but not see us. Is that right?
No, I can see you as well. It's just unfortunate you can't see and hear me.
Because you haven't got a camera on your computer.
No, I can see you.
No. Well, why can't we see you?
I'm not clear. I'm in Chambers. I have done all my video hearings at home in the past and had never had any problem at all. So I'm sorry, I don't know what's wrong, but there's nobody from IT in the building at the moment.
No, there isn't. All right. Well, I'm sorry we've started rather late, and I can tell you that my own computer failed to contact the internet at all, but that has been solved. Our timing is going to be this. We're going to have our first half of the session until about 3 hours from now, about 4 or what is closer to 4:15. But after 2 hours, we will take a 10-minute break because we have found that sitting for long periods of time on Zoom is tiring for all concerned. I should also tell you that there is some fault in the connection between Zoom and various types of computer, one of which is mine, which has the effect that the computer self-mutes. If therefore, and this has happened on 3 or 4 occasions yesterday, if therefore you find that you can't hear me, please wave or make some sign. It's very easy to unmute it. But unless you do that, you may find that I'm speaking away, blissfully ignorant of the fact that you can't hear me at all. I'm afraid the computer systems are about as user-friendly as a cornered rat. We'll have to proceed as best we can. So I think we begin with Mr. Moverley Smith.
Lord, yes, good morning.
No, it's the-
Can I just check before we start that 2 late arrivals to the bundle have made their way to the bench. The first is the sealed order of the court. The court, I think, sealed the order the day before yesterday, and you should have received a copy of that order, which is the definitive order now.
Gosh, I'm not conscious of having. Is it on the cloud?
I don't think anything particularly turns on it. It's just that it needs to be in the record, really.
Right.
When was it sent? Sorry.
I think Miss Hurrion sent it day before yesterday, I think it was.
Well, I'd certainly like to see a copy because I find the 2 marked up copies or 3 marked up copies complicated to follow. So I'd like to see, please.
Yes, certainly we can
When we kick off or as soon as possible. So if it could be emailed to the clerk to the court, I'd be grateful.
Yes, we can certainly make sure that happens straight away.
And
And I'll ask if I can ask Appleby to do that. That would be helpful. The other thing is that we discovered yesterday, looking through the bundle, that the translation of one of the Swiss authorities was not the translation that had been agreed. It was a slightly different translation. The correct translation, again, I think was emailed yesterday to the clerk to the court. I'm not sure again whether that's arrived.
I haven't seen it.
I haven't seen it either.
Right. I don't think anything particular turns on the differences in the translation. You'll just see a difference of expression. I have referred to the agreed translation in my submissions, and therefore when you read those, you'll see it doesn't quite marry up. We will certainly make sure the agreed translation somehow gets to you along with that order as soon as possible.
I should say that we have all read the transmission, the submissions, despite the fact that in my case they arrived through no fault of yours, very late. Speaking for myself, I've done so, but in over rather a longer length of time than the 1.5 hours that you suggested might be necessary for the purpose.
Right. I'm very grateful that your lordships had the opportunity to do that. What I was proposing to do was to deal with the four topics I need to address. The first of which is leave to appeal.
Yes.
Then the scope of Order 24, Rule 7. Then waiver privilege, and finally the Swiss law point, Article 400 of the Swiss Code of Obligations. And the courts directed that the application for leave to appeal and the appeal proper be dealt with at the same time. And on that basis, what I was proposing to do was to deal with the substantive submissions on each of our points and just deal with leave to appeal fairly briefly by way of introduction, if that's convenient.
Yes.
Thank you very much. So in terms of leave to appeal, the position at the moment is that leave to appeal has been given in relation to 2 grounds. That's whether or not the court can order for the party to provide a detailed methodology as to its discovery, and secondly, as to whether or not there's been a waiver of privilege. In relation to the other grounds, leave to appeal has been refused, and therefore we're making a fresh application to the Court of Appeal in relation to leave on those other grounds. Essentially, they're other aspects of the scope of Order 24, Rule 7, and secondly, the scope of Article 400 of the Swiss Code of Obligations. Those are the outstanding matters. In terms of the principles for leave to appeal, the starting point is the case of Iran Nabuvat, which you will find at tab 21 of the authorities bundle. This was a case where a single judge of the Court of Appeal had given leave, and one of the parties was seeking to undo that result by claiming that the full court should revisit it. And in the course of analysing the role of the Court of Appeal at page 1117, Lord Donaldson made some observations about the test to be applied. At letter C on 1117, he says that the grant or refusal of leave is a sensitive power which has to be exercised by the court. The bias must always be towards allowing a fourth court to consider the complaints of a dissatisfied litigant. And then he explains why that should be. And then he says at letter F, I have no doubt at all, no one should be turned away from the Court of Appeal if he has an arguable case by way of appeal. And then over the page, he says, the last sentence at letter A, that is really what leave to appeal is directed at, screening out appeals which will inevitably fail. So there is a pretty low test in relation to leave to appeal. The reason I took the court to that case is because if you turn to tab 27, you can see the Court of Appeal in Bermuda adopting that test. This is in the Abicola and Lisa case of 2007. And you'll see Justice of Appeal Evans at paragraph 3 states that the relevant principles of those we've just looked at. Of course, the position in England is different. If you turn to tab 6, you'll see there the English CPR 52.6, and that provides that permission to appeal may only be given where the court considers the appeal would have a real prospect of success, which is obviously a higher test than the one in Bermuda, which is the one I just referred to. And so in relation to that very low threshold, we say we clearly have passed it. We would also refer the court to 2 other cases. I don't think I necessarily need to go to them at the moment. There's a Gilchrist case and Buckle and Holmes, which are cases that make a point that leave to appeal can also be granted when there's a question of general public principle raised.
Can you give me the references,
Yes,
please?
of course, certainly. It's tab 15 is the ex parte Gilchrist case. And the second case is Buckle and Holmes, which is the following case at tab 16. Which was a case about whether cats were feral animals or not. And the relevant passage in that case is at page 127, the beginning of the judgment of Lord Justice Banks. But again, I wouldn't imagine there's much dispute that those are areas where the court would be prepared to grant leave to appeal, even if it was not necessarily satisfied under the general test. In relation to that aspect, we would say the interrelationship between Order 1A and the rest of the rules of the Supreme Court to which it's been grafted had not previously been explored by the court. A question of general principle is raised for the first time, and it would be of the public advantage for that position to be clarified. So those are our submissions on leave to appeal. With that, unless there's anything further I can add, I'll just make one further observation, which is my learned friend has referred to the Avicoli case we were looking at a moment ago at tab 27, and pointed out in paragraph 4 of that judgment, Justice of Appeal Evans said that where the court was asked to reconsider a judge's exercise of discretion, in this case, he says, to refuse leave, it's necessary to point to some serious error of fact or law made by the judge which could lead to his decision being reversed. That's essentially treating the application for leave to appeal to the Court of Appeal as being an appeal from the decision of the judge at first instance to refuse leave to appeal. In our respectful submission, that's not the correct approach, because there is a jurisdiction given both to the Court of Appeal and the judge at first instance, a concurrent jurisdiction, and we are applying to the Court of Appeal as essentially the first instance body in relation to appeal. So whilst that observation is made, in our respectful submission, it isn't something that the court should adopt. And you'll see, in fact, that it was adopted by counsel by way of a concession in paragraph 4.
Mr. Leonard seems to have missed a trick in that case.
Yes.
if all that he needed to show was an arguable case, it's unnecessary for him to say that the discretion wouldn't be exercised unless that you could point to some serious error, unless
Yes.
it means an arguably serious error.
Yes.
Right, okay.
Anyway, in that case, you probably see from paragraph 18, he said the appeal was entirely without merit. So
Yes.
it all, I suspect, was pretty academic.
Yes.
So that's what I was.
Mr. Moverley, apart from the two bases on which you have been granted leave,
Yes.
what you say involves a general principle raised for the first time, matter of public interest.
In relation to the matters for which leave has been given, it's the same point about the scope of Order 24, Rule 7 and
Yes.
Order 1A. And the fact that essentially what's happened is Order 1A has been grafted to the rules without any other amendment being made to the rules. And the question is, how should the two interrelate?
Yes, my question is, how does that affect the other grounds on which you seek leave?
In my respectful submission, it doesn't affect it. All we could say, I think, is that the additional grounds where the learned judge has refused leave are essentially the same, raise essentially the same point. And so in relation to Order 24, Rule 7, the additional points essentially take the same issue in relation to Order 1A and address that. So to that extent, I suppose it gives support for the argument that we should be given leave, because it makes sense to deal with all those points together, they all being points of general public importance. Does that address my Lord's concern?
Well, I think I understand you. Yes.
Yes, thank you. So if I could turn to Order 24, Rule 7, I think the first point to make is that this was an application under Order 24, Rule 7, and you can see that from the evidence filed in support of the application. There's an affidavit of Miss Roche that's at tab 2 of bundle 3. And if you look at paragraph 3 of that affidavit, you'll see that she says in terms this is an application under Order 24, Rule 7.
Sorry, tab 2 of bundle 3.
Tab 2 of bundle 3 should be, I hope it is, an affidavit from Miss Roche, I think her first affidavit.
Yes.
And she says what the application is about in paragraph 3 of that affidavit. then it's an application under Order 24, Rule 7.
Yes, that gives rise to an interesting question, because the summons doesn't say that it's an application under Order 24, Rule 7. And if the court were to come to the conclusion that it had jurisdiction to make that which the summons asked for, but not under Order 24, Rule 7, is it disentitled to do so because of paragraph 3 of this affidavit?
Well, the application was advanced on the basis it was an application under Order 24, Rule 7. And I was going to say, if you look at the judgment, you can see that the learned judge addresses it on that basis. It is an interesting point, because normally you would anticipate that the rule under which the application was made would be stated in the application. So
Yes.
it is slightly curious in that sense. But what I was going to do was to refer your lordship to the judgment. This is bundle 1, tab 1. And you'll see that in the summary of what the case is about, at the very, very top of the page, under the word ruling, the Chief Justice has referred to it as an application for specific discovery, scope of Order 24, Rule 7. So I think he was clearly thinking it was. And then you can also see, if you turn into that judgment at paragraph 52 and then paragraph 53, but I'm taking a point in paragraph 52 that this is an application under Order 24, Rule 7, and therefore limited by the terms of the rule. And the Chief Justice is noting that at paragraph 53 and saying that because of the provisions of Order 1A, the rule, i.e. Order 24, Rule 7, is to be interpreted by reference to Order 1A, and in that way he then seeks to make the orders he does. So he's looking at the impact of Order 1A on Order 24, Rule 7 to come to the conclusion he comes to.
Well, I see, but I mean, there's an illogicality in relation to this. One matter which he ordered was that you should give an affidavit specifying the methodology that was used.
Yes.
Order 24, Rule 7 doesn't in terms say that.
Precisely, my lord, and that's our point.
Yes, but I mean, if the position is that either under its inherent jurisdiction or by virtue of the overriding objective, the court has power to make such an order, and the judge was within his discretion in doing so, are you saying that we should allow the appeal because it doesn't come within the precise wording of Order 24, Rule 7?
I'm saying that the application the court was addressing and the application which is the subject of the appeal is an application under Order 24, Rule 7. And the question is, what is the scope? What can you order under Order 24, Rule 7? As to whether or not you can make other orders under other provisions or under the inherent jurisdiction, that's not something that was being addressed on this application.
Well, Mr. Moverley-Smith, can I just quite understand that? You referred us, I think, to paragraph 21 of the judgment, but where else does the judge say, other than referring to your argument, that this is an application under Order 24, Rule 7?
Well, as I say, you've got the note at the very top of the judgment at page 2, and you've got the passages I've referred to in paragraphs 52 and 53. I agree with your ladyship, but he doesn't in terms say that he's making order under Order 24, Rule 7.
But 52 and 53 is referring to your argument.
I was going to say that that's referring to my argument and referring to whether or not the court had scope to make an order in terms of essentially paragraph 50 under Order 24, Rule 7, which is the point I was making.
But where the judge himself, in, for example, paragraph 53, is not, in my view, but persuade me otherwise if you wish, concluding that the application was indeed brought under Order 24, Rule 7.
Well, in our submission, the reason he's set out my point in in paragraph 52 is to address that point in paragraph 53. So what he hasn't said in answer to the point I was raising is this isn't only an application under Order 24 Rule 7, it's an application under the inherent jurisdiction, and therefore I can make an order under the inherent jurisdiction, whatever you say about Order 24 Rule 7. He's not said that. He said, I'm going to interpret the rule, i.e. Order 24 Rule 7, by reference to Order 1A.
Well, he doesn't say that.
No, not quite.
Um,
He seems to treat
I-
Order 1A as a separate basis.
And help me on this.
Yeah.
Let us assume, don't make any assumptions about our thoughts, but let us assume that we were to come to the conclusion that Order 24 Rule 7 did not entitle the judge to order that you should explain the methodology, but that either the overriding objective provisions or the inherent jurisdiction of the court entitled him so to do, and that being entitled so to do, it would well have been within his discretion to do that which he did. Are you saying that we should allow the appeal on the grounds that if it doesn't come within Order 24 Rule 7, that's it?
Well, we are saying that the Court of Appeal is only seized of the application that was before the court. And that wasn't an application other than an application under Order 24 Rule 7.
Well, that goes back to what was the application before the court.
Yes.
And the application before the court is that which was contained in the summons, which was for the relief there sought.
Well, one could say that, but then of course one has to look at the evidence in support of the summons that explains what the summons was intended to be.
Mm-hmm.
So I agree with your lordship that the summons hasn't helpfully explained the basis on which the application is being brought, but that has been explained in the affidavit, and that, on my respectful submission, is the only proper way to construe the summons, which is it is as described in the supporting affidavit.
Okay.
And so that's what we say in relation to what application was before the court. In terms of what Order 24 Rule 7 says, that's at tab 4 of the authorities bundle. And you'll see that it makes clear the type of affidavit that can be ordered on an application under this rule. So it's an affidavit stating whether any document specified or described in the application or any class of document specified has at any time been in the possession, custody, power, or etc. Of the deponent.
Well, the judge didn't do that, did he?
The judge didn't do that, and that's the point. That's what he should have been doing if he was making an order under this provision. And our point is that you can't ignore the content of Order 24 Rule 7 and provide for some other affidavit under that rule, because those provisions are clear and therefore it's, in our respectful submission, not open to the court to order any other affidavit under that rule.
Leaving aside the application of the rule, do you accept that either by virtue of the overriding objective or the inherent jurisdiction of the court, it would be open to the court, for instance, to order a party to explain the methodology that it had used in giving disclosure?
I think you would have to find a rule of court that provided for that.
So the answer,
the answer is a tentative no, but I do concede that under the rules under Order 1A, and in particular 1A4, and you'll find it at tab 3. The court is able, or is required, in fact, to actively manage cases. And Order 1A4 to L enables it to give directions to ensure that the trial of the case proceeds quickly and efficiently. So to that extent, you could say the court might have jurisdiction if it's necessary to achieve that aim.
But those are the provisions to which the Chief Justice referred.
He doesn't refer to that specific provision, but I agree in paragraph 54, he does make reference to those rules. But as I say, that's not the application that was before him.
But just a moment. I mean, take this case as an example. There is a dispute between the parties as to how disclosure should be conducted. And one side says to the other, we need to work out what search terms to use. The person to whom that request is addressed says, well, I'm going to adopt the search terms that I think appropriate, and I'm not going to tell you what they are. Disclosure is a matter for me. It can't be the case, can it, that the court cannot say, you must explain what are the search terms that you have or propose to use. The whole system will break down if that can't be done.
Well, as I say, I think you would have to get that within the four walls of Order 1A4.1. I think any difficulty in doing that? Well, I think it would rather depend on what the objections were and how the objections were expressed. But I accept that the court does have obviously their power to give directions, and if it considered that was a direction that would ensure the case proceeded quickly and efficiently, then I can see the court might be able to make a direction along the lines your lordship suggested. But there would have to be, in our respectful submission, an application to that effect.
So I see. So if the summons was under Order 24, Rule 7, he couldn't do that. The judge couldn't do that.
That's right. See, if it's under 24 Rule 7, then he's got to look at the terms of Order 24 Rule 7 to decide what he can do under that provision. I mean, otherwise, as described in some of the cases, you have a completely freewheeling approach to the rules, and all the rules can be essentially ignored.
I'm puzzled by this because the parties put in front of the Chief Justice various proposed draft orders. You gave one set of orders which bear fairly striking similarity to the orders sought. But as I understand your submission, it wouldn't have been open to the judge to make the orders that you suggested that he should make because they weren't within Order 24 Rule 7.
What we did was to volunteer. If you've got bundle 1 to hand still, at tab 3, you can see the order we were proposing.
Yes.
And in paragraph 1, we agreed that the court could make an order in accordance with Order 24 Rule 7. And then volunteered, but we would swear a further affidavit detailing the requests that have been made of the bank. So that was a second affidavit, which we were volunteering in order to try and compromise the hearing. But we were not accepting that that second affidavit was part of the application under Order 24 Rule 7.
So what are you referring to as that second affidavit?
If your lordship looks at the way the draft orders constructed, paragraph 1 deals with what the court can order under Order 24 Rule 7, and paragraph 2 deals with a further affidavit that deals with the request from the bank.
Paragraph 2, do you mean paragraph 3?
This is at page 46 of the bundle. Am I looking at the wrong page?
I see.
Sorry, I do apologize.
I'm sorry, you didn't give that reference.
I'm sorry, I do. Yeah, your lordship's entirely right. I do apologize. Page 46, yes.
Can I just be clear? The draft order, which starts at, I think 38, my numbers have been cut off. The Hurrion draft order with Appleby proposed amendments.
Yes.
That was lodged before the hearing of the application, was it?
My recollection is this was in consequence of the application. The learned judge had delivered his judgment, which included the paragraphs where he ordered us to make various statements in the affidavit, and this order reflects what's ordered in the judgment.
Yes,
so if
that's
you go through the judgment, you can see the paragraph. So yes, so that's post the hearing. Pre the hearing is page 46.
So yes, okay. So you say that what you were proposing in paragraph 2 was an act of grace, because you couldn't have been required to provide that.
Yes.
And if this argument be correct, we needn't concern ourselves with the true meaning of the Swiss legal code, because as I understand you, you say that whatever the Swiss legal code is, since the application was confined to Order 24, Rule 7, the judge hadn't got power, and nor have we, to require the bank to comply with its obligations under Article 400.
Well, in terms of the request is clearly not something that can be ordered under Order 24, Rule 7.
Yeah.
We have already told the court in the evidence that the bank has been requested to provide documents, and the issue that was raised on the application was the scope of the Article 400, and therefore what the bank could be required to provide. But your lordship's right in terms of where it gets the plaintiffs. Your lordship's right that there's no order that actually gives any teeth to the finding under Article 400.
So if you're right, what I put to you a moment ago was correct. If you are right, it's immaterial whether the bank could be required under Article 400, because you say that in these proceedings, the court below and the Court of Appeal above had no power to make any order, because it doesn't come within Order 20, to that effect, because it doesn't come within Order 24, Rule 7.
Well, Lord, I think if you look at if we can turn to the order that's been made, just for a moment.
Have we got that now? Because Appleby somebody needs to send it to us.
I don't know if
the order is on the cloud, my lady.
Well, can you wait a moment, please?
While we're waiting, Mr. Moverley Smith, are you to be understood to be taking issue with the proposition that whatever provision of the rules might be invoked, the overriding objectives are always at play?
The rules need to be interpreted by reference to the overriding objective, my lord, yes.
Okay.
And so to that extent they're in play, but what they can't do is contradict the express terms of a rule. So if you apply under Order 24 Rule 7, the court can't simply ignore the terms of Order 24 Rule 7 and make a totally different order than that which the rule provides for, is our point. But if I could just come back to the point my Lord President was making in relation to Article 400. If you look at the order, you'll find that there is actually no order at all about Article 400. There's simply a recital that the court has found what it found in relation to Article 400. There's no order that flows from the finding about Article 400.
Why do you say that? Item 3 of the order made in the place where I've got it, by the draft order attached to the judgment, required you to confirm by way of affidavit that you had required the bank to do what is theirs to do.
And the position in relation, yes, so that comes back to the Order 24 point, that this is outside the scope of Order 24. But meanwhile, the court has made a finding as to what the bank is required to provide. So even though the court didn't have power to make us request the bank to provide the documents, what it did do was to make a determination as to what the bank should be providing to us. And therefore, that's the aspect we're appealing, albeit that it doesn't actually have teeth in the sense that all we're required to do is to confirm we've asked the bank to provide the documents.
Well, wait a moment. This is unreal. If you're required to confirm that you have required the bank to do something,
yes,
you can only honestly do that if you have required the bank to do something.
Which we
so
have.
in effect, sorry?
Which
so
we
in
have.
effect, required or requested. That seems to be the distinction. You say you have no power to require, only to request. The judge has held that you have power to require, which you disputed in the argument about Article 400. So what he has done is to require you to confirm that you have required. To say that the judge hasn't made any order appears to me unreal. He's resolved the issue as to whether the most that you could be expected to do is to request, and to hold that you can require, and to require you to require by requiring you to confirm that that is what you have done.
But essentially what the court has done is to make a finding as to what is meant, or what
yes.
should be meant by the request or requirement.
Yes.
But that is, in terms of Order 24, Rule 7, that is not something he could require us to confirm in the affidavit.
Quite.
What I'm saying is what he hasn't done is to make any direct order that we should be taking steps in relation to the bank to obtain the additional documents that would otherwise be outside the scope of Article 400. So he hasn't done anything in relation to that.
Well, I suspect
we've asked.
No. You must confirm that you have required.
Required.
If you file an affidavit which says, or fail to file an affidavit, that will be because you haven't required. So you will find yourself subject to an order that you should. And indeed, this is in effect, an order that you should, because it requires confirmation that you have.
Yes, well, I see what your lordship says, but in terms of the consequence of the appeal, if the court is not attracted by the argument in relation to Order 24, Rule 7,
mm-hmm.
then from what your lordship's just said, and in any event from the recital in this order, we would invite the Court of Appeal to revisit the decision as to the scope of Article 400. So,
well, you've invited us to do that anyway, because you say the judge got it wrong.
Yes. So maybe I'm slightly going around in circles, but essentially what we're saying is none of these additional features of the affidavit were permissible under Order 24, Rule 7.
Yes, because you say the sole power that the judge could exercise was under Order 24, Rule 7, and that is it. And the facts, if it be such, that he could use the overriding objective or some inherent jurisdiction is neither here nor there, because that wasn't the basis of the application.
Yes. And I mean, the court, yes.
Yeah. But, I mean, the notion, I'm speaking entirely for myself at the moment, but as I said before, the notion that the court cannot make orders in appropriate cases, such as requiring confirmation that various steps have been taken, or an explanation of the methodology that's been used, or the search terms. I mean, a functioning legal system can't really operate in the modern world if the court can't do it.
Well, as I say, it's a question of what application was the court dealing with. And I come back to that point.
Right. Okay.
Okay. If I could just
Sorry, can I interrupt you once more? I'm
Of course,
sorry to
please.
do that. The order that we've been sent is not dated or sealed. Is there not an order that has been dated, signed and sealed? So we've
There is one. I'm sorry, I thought that was what was being sent to you. It's an order dated the second.
It looks as though it's the final draft, but I haven't got a scanned copy of the actual order.
I apologise for that. I'm not quite sure what's gone wrong there, because there certainly is one. I've got it in front of me.
Well, the one that's just been put on the cloud for us is not the. I'm just concerned that I have the final order in front of me.
Yes,
not
of course.
Appleby's draft of the final order.
Yes.
Yes. The one I'm seeing uploaded at 7:24 this morning by Mr. Quayle. That's the one my lady is referring to, I take it. It's not sealed or signed, dated or signed.
Yes.
Well, I've got one. I found one on the cloud which is both sealed and signed.
All right.
Oh.
Well, I'll have. It's my fault then. Let me have a look. But when I looked a moment ago, it wasn't.
I had to come off the site and then go back onto it in order to.
I would invite you to share the screen I've got here, but unfortunately the order I've been sent is sideways, so that probably wouldn't make.
Well, you can turn them if.
Yes, I could.
I'm sufficiently computer literate to learn how to rotate them.
Yes, I think I've found it. It's a bit.
Okay. Well, don't wait for me. I'll find it.
Yes,
It's listed.
I've tried sharing the screen. I don't know if that's worked.
Yeah.
Okay. I'll find it. Don't worry.
Right.
Quick read suggests that apart from a change in the recitals, it's in the terms of the draft attached to the judge's.
Yes, I think that's right. Yes.
Yeah. Judge's judgment ruling.
Yes.
Okay.
So can I just get rid of that? Sorry. Yes. So if I could proceed by reference to what Benyon says about how one interprets legislation, and that's at tab 7.
I think you
Where it
can
refers to the
remove the share screen now, Mr.
So I'm just trying to I'm trying to do two things at once and not succeeding, I'm afraid. If I can just work out how to stop sharing the screen, that would be useful.
Right. And Benyon is at what tab?
Benyon is at tab 7. That might have got rid of it. Yes, sorry, and you'll see that sets out what they call the plain meaning rule, and it's essentially along the lines that if the meaning is plain, the court shouldn't go beyond the plain meaning.
Right.
And you see, for the purposes of the plain meaning rule, the meaning is plain anywhere no relevant interpretive criterion points away from that meaning. In other words, the plain meaning must be given anywhere there's nothing to modify or qualify it. Essential rules, the words should generally be given the meaning which the normal speaker of the English language would understand to bear in their context at the time when they were used. Tab 30 is simply simply establishes that has received judicial blessing, that paragraph. Tab 30 is a case of Kay and Lawrence, and you can see the blessing at paragraph 43.
Tab 13 and the civil procedure rules.
30, 30, sorry.
Oh, sorry, thank you.
Sorry, that wasn't clear, I do apologise. So all I'm saying is at tab 30, you can see the application of that principle. And then tab 38, if you see that at tab 30, paragraph 43, tab 38 is the Supreme Court, the English Supreme Court decision in Williams and Central Bank of Nigeria. And the judgment of Lord Newburger at page 1217, paragraph 72. You should see it letter E, a couple of sentences. Where interpreting a statute, the court's function is to determine the meaning of the words used in the statute. The fact that context and mischief are factors which must be taken into account doesn't mean that when performing an interpretive role, the court can take a freewheeling view of the intention of Parliament, looking at all admissible material and treating the words of a statute as merely one item. Context and mischief do not represent a license for judges to ignore the plain meaning of the words that Parliament has used. So that's
well, I follow entirely what you say in relation to this, that it doesn't come within the plain meaning of Order 24, Rule 7, that you can order somebody to say what was the methodology he used in making disclosure. It's simply not there. But all this proceeds upon the hypothesis that 24 Rule 7 is a limiting provision as to the court's powers in relation to disclosure. Order 24 Rule 7 gives the court power to make certain orders. But that begs the question as to whether the court has powers derived from other source to make different orders, including an order as to what was the methodology used in applying, seeking to comply with the obligations of disclosure.
Well, I agree.
We were back to, it's all
we're
down
back
to
to the same point, I think, which is, if we are right in saying this is an application under Order 24 Rule 7 and only that, then what the Chief Justice has done is going beyond the scope of that rule. And if one does go beyond the scope of that rule, that's essentially ignoring the.
Was this submitted to the Chief Justice?
I'm sorry.
Was this submitted to the Chief Justice that because of what Order 24 Rule 7 says, you can't order, for instance, methodology because it doesn't come within the plain or indeed any other meaning of those words in Order 24 Rule 7?
Yes, well, you can see that in paragraph 50. You remember, looked at paragraph 52 of the judgment, where that was exactly what I was saying. If you look at the first sentence of paragraph 52. So yes, is the answer, I think, to your Lordship's question.
It's manifestly unsatisfactory. I mean, if you're right, the whole result is manifestly unsatisfactory because there's the possibility that in fact the judge had power to do what he did, and what he did was well within the discretionary power that he did have. But because of Order 24 Rule 7 and the reference to it in the affidavit, he didn't. A more technical approach would be difficult to follow, to find.
Well, I think one has to come back to.
And you're under an obligation to assist the court. You're under an obligation to assist the court in fulfilling the overriding objective.
Yes.
Taking this sort of point might not thought to be within that scope.
Well, I think one has to look at what was the application the court was dealing with, and what order could it and should it have made in that context. And when I look at the authorities.
Yeah, on this hypothesis, the plaintiffs could go back to the court and ask it to make the same order, but under the inherent jurisdiction or under the overriding objective.
Well, I accept that maybe a different application could have been made.
Right.
I thought you did accept earlier when I asked you that the overriding objectives are always at play.
Well, they're always at play in interpreting a rule, but if the rule is expressed as to what you can apply for, then the interpretation doesn't allow you to rewrite the rule.
In terms always at play for the purpose of proper case management.
Yes. but still you come back to the wording of a rule. I mean, it's similar. We haven't put the authorities in, but there are those authorities I'm sure the court's aware of that say you can't go behind an affidavit verifying a list of documents. So my Lord President's point that well, all these other orders could have been made anyway, you run into those sort of issues, that there are established rules about how you can obtain information about discovery and what those rules entitle you to. And those are the ones
none of those rules prevents you from requiring an affidavit as to the methodology that you've used.
Well, I think but I was giving your lordship a different example, which is are you able to go behind the affidavit verifying the list of documents? And if you were to say, well, in relation to that affidavit, we now need you to explain precisely what you've done in your disclosure because we are not happy with what you've verified, then you are going against those authorities, and it would be rewriting the rules essentially as to what the court can require in this context.
Right.
So as I say, I think we still come back to the same point that I made at the beginning, which is this is the application we're dealing with. And I was just going to say, if you look at the order, the number of features of the judgment, which is now turned into the order, where the judge has gone beyond the scope of Order 24 as expressed.
Could you identify those for me, please, where you say that?
Certainly. If you look at, the first few paragraphs are unobjectionable in the sense that he's essentially requiring the defendant to essentially verify its position in relation to the documents. But for instance, in paragraph...
Sorry, Mr. Moverley, could you tell me so I can make a note?
Yes, of
all
course.
Those paragraphs of the order where you submit the judge has gone outside what he was entitled to do.
Yes, so in terms of what's outside the ambit of Order 24, Rule 7, you start with paragraph 26. And
I thought we were looking at the order.
Sorry, I'm looking at the. Sorry, I do apologise. I was looking at the judgment because when I wrote my submissions, of course, I didn't have the order to hand. But I can do it by reference to the order too. So you've got that he required the affidavit to be sworn by a current officer of the defendant, therefore identifying who needs to swear the affidavit. In paragraph 27 of the judgment, where it hasn't made its way, I don't think, into the order, he required that the existing employees designated to undertake the defendant's business should be required to undertake the searches, so identifying who should be carrying out the searches. And then you've got the paragraphs in relation...
You're objecting to that, are you? And where do I see that in the order?
Well, that's what I'm saying to my lady. It doesn't make its way into the final form of the order. So although that's in the sense that...
Are you right about that? Are you right about that? Look at paragraph 6 of the order. Oh no, it's
I don't think
paragraph 7.
So
for the purposes of this order, all references to searches means forensic searches undertaken, including for the avoidance of doubt.
What I don't think he's done is to translate what he says in paragraph 27 into the terms of an order as such.
Well,
I think
that is correct, but in fact, in the draft attached to the judgment,
which obviously must be different to the final order,
the draft attached to the judgment has a paragraph 6, which says, for the purposes of this order, all reference to searches means forensic searches undertaken by / under the supervision of persons qualified to search and retrieve documents.
Yes.
But that for some reason doesn't feature in the order as sealed.
Doesn't seem to have made its way into this draft, no. Into the final order, I should say. Yes. And then the other paragraphs, if you work through the judgment, you can see.
Sorry, can I be clear? What
yeah.
I need to know is which specific paragraphs of the order as sealed you are objecting to
Yes.
or feeling against.
So paragraph 1 of the order requires confirmation in relation to searches, and essentially therefore requires the defendant to have carried out the express searches the court is identifying there.
So are you objecting to all that?
All that is outside the scope of Order 24 Rule 7, yes.
So you object?
Is that the whole of paragraph 1?
Yes, because essentially what paragraph 1 has done is to incorporate all the paragraphs that one finds in the judgment where the judge says, I therefore order. They've all been incorporated into paragraph 1 and all in relation to this confirmatory affidavit. But part and parcel of that confirmatory affidavit is the underlying obligation to have carried out the matters that we need to provide confirmation of, as my Lord the President identified.
And are you objecting separately to the requirement in the second line or the first line of paragraph 1 that it's a current officer?
That again is, I mean, we have no objection to swearing an affidavit by a current officer, and indeed an affidavit has been sworn by a current officer. But in terms of the strict terms of Order 24 Rule 7, it is outside the scope of that provision because Order 24 Rule 7 doesn't provide that the court has the ability to direct who should make the affidavit.
Right, and so
presumably leaving, I mean, we'll come back to this all the time, but presumably leaving aside Order 24 Rule 7, the court could require the affidavit to be sworn by a specified person.
I suppose arguably, provided it could get within the, I mean, under the inherent jurisdiction, I think one's limited by the scope of the rules, and you can't have a freewheeling approach that Lord Newberger was complaining about in the Williams case. But if you could justify what you were ordering under Order 1A, Rule 41L, then I agree. So if you could say it was necessary for the efficient and timely disposal of the action, or whatever the words are in Order 1A, if you could make the order fit within that parameter, then that's an order you could make. But that's what you'd have to do in order to make an order under that provision.
So going on through the order, are you objecting to all or just some part of 1.5, 1.6 and 1.7?
I think they all raise the same issues, which is, or the same issue, I suppose, really, which is in relation to, well, in relation to the obligation imposed on the defendant to carry out specific searches in relation to specific documents. It's couched in terms of a confirmatory affidavit, but essentially what the court is doing here is ordering that various searches be carried out. Under the English CPR, the rules make provision for that to be done. So if we look at the English CPR equivalent,
that's not in play anymore because we've got the new practice direction, haven't we?
Of course, you've got new practice direction anyway. But I mean, if you move away from practice direction, and look at what the rules said before that was introduced. They do provide for express provision of. Sorry, it sounds like my house alarm is going off. I hope nothing nothing happening. I apologise for that. But sorry, in terms of where one gets to, the affidavit as I say, is not something that could be sworn to. And there's no provision, as I say, for searches.
Just so as to be clear, the judge, you say, was not entitled to make any of the orders in paragraph 1 of the order.
He was simply entitled to order us to make an affidavit describing addressing the documents referred to in the application, and to say whether or not they were in our possession, and if they weren't in our possession, when they were last in our possession, in the ordinary way that a list of documents does. So essentially, the affidavit that you can make will be required to make under Order 24, Rule 7, is an affidavit verifying a list of documents.
Right. So none of the provisions in order 1 were open to the judge.
Not in the terms they're addressed here. That's right.
I think yes. So right. The answer is so he couldn't do any of 1. Right. What about item 2?
There's not in dispute. And 3.
Sorry, you mumbled. What about item 2?
Sorry, if I was mumbling, I apologise. So in relation to 2, that's essentially what the affidavit should provide in compliance with Order 24, Rule 7. So he could order an affidavit to be made that would exhibit the list.
So you're not appealing Order 2?
We're not appealing Order 2, except you can require a list.
That's the further and better list, is it? That provision?
I'm sorry, my lord, I didn't quite catch that.
For the further and better list.
Yes.
Order 2.
Yes, my lord.
And then I assume you say that you couldn't make anything in paragraph 3 of the order?
In relation to paragraph 3, again, that's outside the scope of Order 24,
Right.
7, for the same reasons we discussed. And also paragraph 5. So essentially, the court was limited to the terms of Order 24, Rule 7.
Well, wait a minute. You couldn't do.
Sorry. I do apologise.
My lady, your question.
Can I be clear? Are you appealing against 4 and 5 as well on the same grounds?
My lady, what we were appealing at the time was the judgment, because there wasn't an order. But 4 and 5 raised the same issues, which is, can the court make orders outside the scope of Order 24? So yes, I think.
We all know that you appeal orders, and I just want to be clear. Now we've got the order.
All those matters are outside the scope of Order 24, Rule 7. So yes, we are.
Right. Thank you.
Yeah.
And presumably you say the same in relation to 6, even if privilege has been waived.
If privilege has been waived, then we are required under the provisions of the rules in relation to discovery to provide those documents that are relevant. And so that comes under the general obligation to provide discovery.
So if privilege has been waived, you would have to provide those.
Yes.
All right. Right.
Yes.
Right.
Well, in terms of what the learned judge relied on to justify the application of Order 1A in the way he sought to apply it, he referred to the case at tab 35, which is a Stiftung Salmodab case. building an opera house in Lucerne, I should say. And in that case, that's, let's say, tab 35, you'll see at paragraph 1, there's an application for specific discovery that had been made. And then if you turn over to paragraph 6, you can see that an issue arose about the fact that if you were seeking disclosure, then you had to prove a guano test, and therefore it was wide. If, on the other hand, you were seeking production under Order 24, Rule 12, then you had to show that was necessary. So obviously a narrower scope. And essentially what happened here, as you can see from paragraphs 6 and 7, was that although the application had been made for disclosure, so the wider scope, the judge proceeded on the basis of the narrower scope, on the basis that what was really being required was production, and that the party seeking production was content to proceed on the basis it should be treated as an application for production and not for discovery. You can see that at the end of paragraph 6. And so what the court did in paragraph 7 was to say, well, I'll treat this as being an application under Order 24, Rule 12, because I can do that applying the overriding objective.
And
So
could
that's
the judge say, I'll treat this as an application under the overriding objective, in the light of the overriding objective?
Well, I don't think the overriding objective per se gives the court the power to make any order it fancies. I think you have to look at the case management provision of Order 1A.
No, it has to be an order that the court think is just or necessary for the fair and efficient disposition of the cause.
Yes, but it needs to, well, fit within the ambit of what we looked at a few minutes ago, which was to ensure the trial proceeds quickly and efficiently, I think was how it's put. But what you don't see is the judge doing that as such. He's saying we're going to treat this as an application under Order 24, Rule 12, essentially. But my point about that case is it really doesn't take the matter that much further forward, and doesn't really address the question of the extent to which the terms of the provisions in the rules as to discovery can be modified or rewritten by reference to Order 1A. If I might move from there to just deal with the authorities learned friend has relied on in support of his proposition that the court can interpret things in that way. The first is a case called Fong and Incredible Power, which you'll find at tab 42.
Do you deal with these in your skeleton argument?
We don't. Just trying to think.
That's for the purposes of my note, that's all.
Yes. I'm trying to remember exactly the order, but we haven't dealt with these authorities. I think these. I'm just trying to see if any of them were matters we had previously dealt with. I think not, because it was a sequential exchange of skeletons. So I think none of these particular cases were referred to.
Okay, thank you.
So if I could go through these at a reasonable pace. So tab 42 is the Fong and Incredible Power case. It was a case in the commercial division of the court in the British Virgin Islands. First instance decision of Mr. Justice Wallback. And the thing to note about the BVI is it's got its it's got the Eastern Caribbean Supreme Court civil procedure rules, which largely follow the English CPR. So you have a modern set of rules as opposed to the position in Bermuda where you're still looking at the RSC. And you can see if you look at paragraph 1 of the judgment that the application was made for specific disclosure pursuant to rules 28.5, 28.16, and or the court's inherent jurisdiction. So they covered all bases in this particular case. And then if you turn on to paragraph 24, the court considered the question of whether or not it could order a party to give evidence about searches. And you'll see from paragraph 24 that two specific powers were identified under Rule 26, 26.1.2f and 1.2w. That's footnotes 12 and 13 to the judgment. And 12, footnote 12 is referring to the ability of the court to direct that evidence be given in written form. And 13 was to give any other direction or make any other order for the purpose of managing a case and furthering the overriding objective. So you can see in relation to that provision, that's considerably wider than the provision in Bermuda. And then there's a reference to the inherent jurisdiction. You can see what the judge says about this sort of freewheeling approach that was being deprecated by Lord Newburgh. If you turn through to paragraph 62, and you can see there Mr. Justice Wallbank says that CPR 28.51b permits the court to order a party to search for documents. So that's according to the search powers referring my lady to earlier. But the court must also be satisfied that criteria for making an order for specific disclosure are fulfilled. These go beyond considering whether documents or a category of documents are directly relevant and should have been disclosed in advance of the standard disclosure obligations. So that's what was in play. And then he says at paragraph 63 that what the claimants were seeking was to obtain material that was or might well be not directly relevant, because until they can see the material they won't know whether it's relevant and therefore falling within the obligations of disclosure, which is the issue being raised in paragraph 63. And that led the claimants to make the submission in paragraph 64 that the court had power to order specific disclosure of documents that were not directly relevant, including those that may lead to a train of inquiry. So basically opening up disclosure to the proven guano test, even though the express provisions of the rules limited disclosure to directly relevant documents. So that was what was in play. And what the claimants relied on was a decision of Justice Leon in a case called Yao and Kwok, where he said the court's permitted to develop a customized approach to fit the case. It's not hamstrung by any attempt by rule drafters to micromanage the process. There's a significant element of trust for the court. This was what Justice Leon said. And you can see there's a reference then by the judge to another case, Barclays Bank and Red Oak. And you can see at paragraph 70, the judge is persuaded that that's the appropriate course to adopt and not the one suggested by Justice Leon. And he says in relation to that freewheeling approach, paragraph 71, no reference to authority to justify it. And then at paragraph 72, he says the suggestion that litigants should trust the court militates against the spirit of the CPR. The litigants should be able to know, as far as reasonably possible, where they stand with regard to their procedural obligations and rights. Ambiguity is implacable enemy of the orthodox hermeneutic. The drafters of the CPR have gone to great lengths to eliminate guesswork, the debilitating notion that legal proceedings are ill-lit, endless labyrinth, endless labyrinth where litigants are at the mercy of judicial officers, all too often seen as covered in the double cloak of confusion when it comes to common sense and day-to-day realities. So that's what he was saying about the approach adopted by Justice Leon. And then he talks about the general catch-all power, as he puts it in paragraph 73. He says, dealing with the disclosure provisions, he says, this is to be contrasted with explicit matters the court may order as part of its case management powers. They're carefully spelled out, ending with deliberately expressed catch-all power. There's no catch-all power expressed in 28.5. On the judge's interpretation, such a power would need to be implied. For my part, I'm not persuaded the drafters of 28.5 intended to leave such a matter to implication, particularly in the context of an otherwise carefully circumscribed procedural regulatory scheme. So he's going back to the proposition that you are bound by the rules and can't make it up as you go along, essentially. He then deals with methodology at paragraph 151, if you could turn on to that. And you can see that he takes the view that he's not satisfied that proper searches have been carried out in paragraph 151. And then over the page at paragraph 155, the scheme of standard disclosure envisages self-certification. No express provision for appellant to go behind self-certification. But then he basically says, well, notwithstanding that, I can go behind self-certification by reference to the overriding objection. You see that in paragraph 156. But that is by reference to the specific provisions of the Eastern Caribbean Supreme Court rules. So the list identified in 156. And says the power should only be used sparingly. There's the same in relation to the RSC. There is a significant authority saying you can't go behind self-certification. So what we were doing would be essentially introducing into the established position in relation to discovery under the RSC, the approach being adopted here in relation to the CPR. And our respectful submission, that's not something that's permissible. The next authority is in relation to the court's inherent jurisdiction, and that's the case at tab 33, the Al-Rawi case, which was a case about the closed procedure adopted in relation to material that's subject to public interest immunity. And what's useful, I think, at paragraph 574 in the judgment of Lord Dyson is his analysis of the inherent jurisdiction of the court. And if you just take that up from letter A down to letter G, I won't read that all out. But in relation to the position in relation to rules, at letter B, he says that the court may exercise its inherent jurisdiction.
Sorry, I'm missing the paragraph number.
Sorry, I do apologize. It's paragraph 18. Sorry, I should, yes, I should.
In your Dyson.
Yeah, I do apologize. Yes, so it's page 574, paragraph 18
Yes.
is where it starts.
Thank you. I'm there. Thank you.
And then I was looking at paragraph, the bottom of that paragraph, where they talk about where the court can exercise its inherent jurisdiction in respect of matters which are regulated by statute or by rule of court, so long as it can do so without contravening any statutory provision. In such a case, its power has been removed by statute and cannot be exercised. So to the extent the rules have provided as to what can be done in relation to discovery under Order 24 Rule 7, you can't pre-enade the inherent jurisdiction.
That can't be right.
This was the case dealing with whether or not material that have been protected by public interest immunity,
Yes.
the order to be disclosed. So,
Yes.
there was a direct clash of established common law principles.
Yes, that's right. So that's what was being considered here. And the question was, could you introduce a new regime in relation to matters covered by public interest immunity?
But
And they said,
sorry.
Sorry.
They held that that had to be left to Parliament.
Yes. That's the issue.
But what Lord Dyson says there is that the inherent jurisdiction can't be used so as to contravene legislation or rules of court.
Yes.
But if you were to order, for instance, a party to explain the methodology by which he approached disclosure, that would not contravene any rule of court. Order 24, Rule 7 gives the court a power which it may or may not exercise, but it doesn't say anything which says expressly or impliedly, and what the court can't do is ask somebody or require somebody to explain how he went about things.
I think the problem is that if one adopts the approach that one can make any order the court one likes, where an application is made under Order 24, Rule 7, it completely defeats the purpose of the rule, spelling out the sort of affidavit that could be provided. It's
So
now
is
become entirely redundant.
So is your position, therefore, that even if the appropriate application had been made, it would not have been open to the judge to make an order requiring explanation of the methodology, because that would be inconsistent with Order 24, Rule 7?
The court could make an order under Order 1A, because I think our position is that in terms of litigation, unless you can see an actual gap in the rules provide for how things should be done. And therefore you need to find a rule, whether it's Order 1A or Order 24, Rule 7, in order to be able to make an appropriate order in relation to civil procedure, unless you can spot a gap. And if you can't spot a gap, then you'd have to get within Order 1A, Rule 4.1, and presumably in this context, sub-rule L, and say, well, I can make a direction that enables the matter to be dealt with justly and promptly. I'm just misremembering precisely what the provision is. Proceeds quickly and efficiently. So you'd have to make your order fit within those criteria if you were making it under CPR 1A. Sorry, RSC 1A.
I'm sorry, I've got slightly lost.
Yes, probably.
You said unless you can see a gap in the rules, you have to bring yourself within Order 1A.
You have to, yes, you have to bring yourself within the RSC, which includes Order 1A, and also if you want to make an order in relation to the management of the case, then you have to fit within the criteria of 1A41L, which is what I was just reading out. So in order to make the proceedings operate quickly and efficiently.
So as I'm understanding you, and maybe I'm just putting the same question again that my lord has just put to you, but you're effectively saying that unless you can bring yourself within the specific disclosure rules, you can't, as it were, use 1A to dig yourself out of the restrictions or the confines of the specific rules.
Essentially, yes.
Yes, thank you.
Unless, as I understand it, the order is required for the efficient management of the case.
Yeah, if an application's made under Order 1A, then the court can make other orders, and I agree those other orders might relate to matters of discovery or matters of who swears affidavits and so forth. If you can justify it on that basis, Lord, yes, entirely.
Well, I'm not following you, because I thought you answered my question a moment ago. That to the effect that you couldn't use 1A to escape from the confines or the limitations of the specific discovery rules. Now
Yes.
you seem to be saying, in answer to my Lord Justice Smelly, that you can.
So I perhaps wasn't entirely clear. What I was saying is that to the extent the rules deal with matters, so they deal with specific discovery, for instance, then you're confined by the rules. To the extent you're dealing with something beyond the rules, so for instance, who should swear an affidavit, and if you can show that that's necessary for the efficient and quick resolution of the proceedings, then you might be able to make an order under that provision. But what you can't do is to deal with matters dealt with by a specific rule under the RSC in a manner that's different from the way the rules require it to be dealt with. In other words, you can supplement by Order 1A, you can't rewrite applying Order 1A. Does that provide a bit of clarification, my lady?
Well, I understand what you're saying to me.
Yes and no, but it provides further obfuscation, because if the position is that you can supplement, the Order 24 Rule 7 talks about swearing an affidavit as to whether the documents are or have been in your possession, custody or power. Presumably that means that you can specify who shall swear the affidavit.
If and to the extent you can be satisfied that that's necessary for the efficient disposal of the proceedings, then I suppose in theory you might be able to, but I think you're then trespassing very close to the line, in the sense that the rules have made provision for an affidavit to be made, and essentially what you're then doing perhaps is trespassing over that line by trying to dictate other requirements for the affidavit. So I think...
So forgive me, this is nonsense. The rules require that an affidavit be sworn.
Yes.
They say nothing about who shall swear it.
Yes.
So in accordance with the rules, you could get a 3-month paralegal who doesn't understand disclosure to swear the affidavit. Can't possibly be right that the court can't say the affidavit must be sworn by somebody who knows about the case and is capable of approaching discovery in the proper way.
Okay, well, I fully accept that the obligation to provide this discovery requires the affidavit to be sworn by a person able to verify what he's verifying. And therefore, obviously, it has to be somebody proper. I entirely agree with your lordship, yes. All I'm saying...
Wholly inconsistent with your statement that the judge was wrong in specifying who should swear the affidavit.
My lord, what he was able to order was only that an affidavit be made. The obligation on the party is to ensure the affidavit is made by someone able to depose to what he's deposing to.
So if they swear by somebody who appears to have no knowledge of the matter at all, the judge can do nothing about it. Is that what you say?
I'm saying that then would not be a proper affidavit. I think the complaint would then be made that the affidavit hasn't been made by the appropriate person. And
so
therefore,
the judge could order it to be made by a specified appropriate person.
He could order a proper affidavit to be made, I think is where one gets to.
So he couldn't specify the person. This is, forgive me, this is ludicrous. Literally ludicrous, one might think.
Well, I think the question really, my lord, is whether the rules provide the mechanism for dealing with specific discovery, and they do on the face of it. Those are the rules. The rules have been in place for a long time, but they are very clear as to what a party can and cannot get on an application under Order 24, Rule 7.
So to go back to paragraph 1 of the order,
yes,
as I understand it, and this is what you told us when you went through, you're saying that it's outside because it's outside what's permitted by Rule 24(7, the judge was not entitled to order the defendant to swear this affidavit by a current officer.
Yes, I'm saying the affidavit he has required to be sworn here is not the affidavit that he has the power to require to be sworn under Order 24 Rule 7.
Not least because he can't say sworn by a current officer.
Order 24 Rule 7 doesn't make provision for the as to who should be ordered to swear the affidavit. But I've already made the point. I've made the point as a matter of practice. One inevitably would have to have it sworn by someone who knows what they're talking about.
But am I right that you're saying that he can't use, the judge can't use Order 1A to insert the words sworn by a current officer of the defendant in any circumstances, because that's inconsistent, you say, with the power under Order 24 Rule 7? So you referred a moment ago to that you accepted that you could use Order 1A to supplement.
Well, it's a nice point as to whether or not the provisions of Rule 7 are all-encompassing in terms of the type of affidavit that can be sworn, which we say they are, and whether or not being prescriptive as to the type of affidavit that can be sworn, that can be required to be sworn, that includes saying that the court can't make an order directing who should make that affidavit. It could.
Well, I'm not interested in nice points.
Yes.
What I'm interested in is what is your submission as to whether the judge is allowed or not allowed to insert the words sworn by a current officer?
He's not allowed.
He can't do that, or he can, or he
Under the terms of Order 24.
Just a second, let me finish, please.
Sorry,
are you saying that he wasn't allowed, even if there'd been an application under every single appropriate rule, to insert those words sworn by a current officer, because it's not what's expressly provided for by the rules?
I think yes, my lady, I think the point your ladyship's making is, can Order 24 Rule 7 be supplemented by that further direction, is the question.
Yeah.
Lady, that obviously is not the position that was before the judge, and in relation to that, I think one would have to conclude that the rule as provided, the RSC rule as provided, didn't cover the question of who should make the affidavit, and therefore the court could make an order under 1A. But you'd have to reach that conclusion. And in my respect for submission, it's difficult to reach that conclusion. But if you could reach the conclusion that there's a gap, then I accept that Order 1A can fill a gap.
Well, what is your submission? I mean, you're saying it's difficult. What I'd like to know
my submission is it's not relevant, because there's not an application under Order 1A, under Order 1A 41L. There's no such application. There's no application under the inherent jurisdiction. There's only an application under Order 24 Rule 7. And therefore, what might have been the position is not something that the court needs to address today.
Okay, assuming that we were to treat de bene esse, an application being made under Order 1A as well, is your submission that this is one of those occasions where 1A can be used to supplement 24/7, or are you saying, which is what I thought you said when we were going through these paragraphs, are you saying no, because of what's expressly said in 24/7, that's all you can do, what's expressly said, you can't supplement?
Well, lady, I think when we went through the order, I was looking at that by reference to Order 24 Rule 7. So I don't think I was expressly, if I wasn't intending to expressly address the position as to what might have been a position under 1A. My lady, I am, I suppose, prepared to accept that it could be seen as being a gap, in the sense that the wording of Order 24 Rule 7 doesn't really address who should make the affidavit in terms. And therefore, I think you could say that possibly there was a gap. But you'd have to get to that point in order to be able to reach that conclusion.
Thank you.
Sorry, that's very long-winded way.
I asked Mr. Moverley Smith as to whether there needs to be a specific application.
Yes.
Is that contrary to the philosophy of the overriding objectives, which I think we have agreed are always at play? You don't need a specific application if there is a gap or lacuna which Order 1A can be used to fill.
Well, Lord, I think if an order is going to be made, it needs to be made on the basis of the application, and the court addresses the application that's before it. The court can, of course, say to the parties, are the parties content that this matter be dealt with as an application under Order 1A 4(1)L? You can obviously invite the parties to consider whether or not that's the way to proceed. But if it doesn't do that, and if it remains an application under Order 24 Rule 7, then the overriding objective can't be prayed in aid to add further orders in the way being suggested.
But isn't it the implicit understanding that the court must approach each application according to the overriding objectives?
But it approaches the application that has been made. So yes, it will look at the application that's been made and will look at the rule that's been sought to be relied on. Of course, it can do that and will do that. But it can't rewrite the rule, is my point.
What it can say is they got the wrong rule, at least in the affidavit, but I can grant the relief that's sought on a different basis. And it would only be just to do so. The overriding objective would practically demand that the court did that.
Well, I think we come back to the point I made before, which is that isn't what was before the court. And whether these orders are appropriate under Order 1A, whatever it is, 4(L), will depend on whether or not the court can be satisfied.
So what's the overriding objective argued? Were there submissions made to the judge, about the Chief Justice, about the overriding objective?
Well, I'm just trying to remember back.
Yes, there were.
I think there probably were, yes. I think my only friend said that...
Page 383 of the transcripts bundle, you can see I refer to expressly.
Yes, that's my recollection. I think that's right, yes.
And you didn't say to the judge, well, you can't deal with the overriding objective. This is simply an application under Order 24 Rule 7.
Well, that is what I did say, and that's what's recorded in paragraph 52 of the judgment. You can see I'm saying you're hidebound by the terms of Order 24 Rule 7. So I was making that submission. I'm conscious I'm using up quite a lot of time. Yes. I was going to contrast Order 1A with the provisions in the English CPR, but you've seen the equivalent of those in the Caribbean CPR, which is take any other step or make any other order for the purpose of managing a case or furthering the overriding objective, which is obviously broader than what's permitted in relation to the overriding objective in Bermuda, which is only that the case proceeds quickly and efficiently. And I was just going to make the point that therefore was a lesser jurisdiction given to the court in Bermuda. My lady friend at tab 39 refers to an Irish decision, Irish Bank Resolution Corporation, and I think the relevant paragraphs are possibly paragraph 50 that identifies what the case was about. It was about whether or not you could use predictive coding in relation to discovery. And then you can see that they do find there's a gap. If you look at paragraph 59, where the judge finds that there is a gap because there's the absence of a specific rule about it. And then he quotes from a case called Dome Telecom. Mr. Justice Gregory. And you can see that he takes a very relaxed view about the rules. If you look at the top of page 12 of the judgment. And basically he says, as you can see, 2/3 of the way down that paragraph, the court, even if there's no rule in existence precisely covering the situation, has an inherent power to fashion its own procedure, and even if there were a rule applicable, the court is not necessarily hidebound by it. So he's adopting very much the freewheeling approach that was deprecated by Lord Neuberger. The learned friend refers to a case called Pyro Investments and NBW, which is the next tab. I don't think there's much to note there other than that it was another case about predictive coding, and the court approved the use of predictive coding as paragraph 1 of that decision. But beyond that, it doesn't really take the matter very much further forward. The learned friend then goes to Hong Kong, and that's tab 36. And this is a case where e-discovery was sought under Order 24, Rule 7, which is in the same terms as Bermuda. And you can see that from paragraph 15, so page 10 of the judgment, tab 36, you can see Order 24, Rule 7 is in similar terms to Bermuda, and as is Order 24, Rule 8, which is on the next page. And he then says, this is Mr. Registrar Lung, he then says at paragraph 16 what the requirements are for discovery, and then over at letter E on the following page, so page 13, says it's clear that post the CJR, which is a civil justice review, the court should give effect to the underlying objectives of the rules and procedures when it exercises its powers under Order 24, when it interprets the provisions of Order 24. And then you can see, if you turn through to paragraph 27, he says the parties should bear in mind the court's approach in its case management role in the discovery exercise. He then refers to the civil justice reform. The court should be expected to exercise its case management powers with a view to tailoring an appropriate discovery regime for the case in hand, should have residual discretion to narrow or widen the scope of discovery as required. And then if you turn over the page to paragraph 28, letter E, you can see that that was implemented by the introduction of a new rule, Order 24, Rule 15A, which gave the power to the court to limit discovery.
Of course, we've got that in the UK and in England and Wales anyway.
Exactly, yes, yes. And you can see that's really my next point. If you then turn over the page, you can see he makes a reference to the Digicel case in England, and he relies on that case. If you turn through to paragraph 42, to conclude that the plaintiffs are entitled to request the solicitor to make a reasonable search. So basically he's relying on the English power to direct a search under the CPR, and mistakenly assuming that that's a power available to him under the RSC. And he makes a reference to the power of the court to give directions to parties rediscovery by reference to the Hong Kong, that is Order 1B, and you can see from the footnote that that's in the English terms, not the Bermudian terms. And
Right.
you can see, in fact, when he gets around to making the orders he makes, basically he dismisses the application almost in its entirety, save that he makes an order in traditional terms under Order 24, Rule 7 in paragraph 65. So it's a case actually that results in a traditional order being made under the rules. Well, I think the only other point I was going to make in relation to this aspect is the fact that Order 24, Rule 8 provides that discovery should only be ordered if necessary. And I'd simply refer you to paragraphs 40 onwards of our submissions. That deal with the question of whether or not the Chief Justice has anyway gone beyond the scope of what Order 24 Rule 8 permitted. In particular, paragraphs 39 and 40. If I perhaps just leave that with you, rather than going through all the references there, going around the time. And I think the final point is in relation to the methodology requirement, even if the court had power, should it have ordered it in this particular case. And in paragraphs 43 to 45, we make the point that the circumstances of this case were not that unusual, and therefore the court shouldn't have made what was a totally unprecedented step of requiring methodology to be explained on oath in the detail required. But if I can leave those points by reference to my submissions and move on to waiver.
Would that be a convenient moment to take a 10-minute break?
Lord, it would. I'm very grateful. Thank you. As I say, I've got to deal with waiver and the Swiss law point.
And 10 minutes means 10 minutes, not 15.
Lord, yes.
Okay. Thank you very much.
Thank you.
Hello, can we let us out?
Yes, you can let yourselves out by just hovering over the breakout area. Do you see the breakout area, Sir Christopher?
No. What am I supposed to? Oh, I see. Yes, I'm so sorry. Oh.
Right, are we all assembled? Mr. Hollander, are you with us?
Yes, I am.
Good, good. Right. I think we've got to waiver. Is that right, Mr. Moverley Smith?
Oh, yes, that's
Yes.
Just in relation to waiver, this arises under paragraph 47 to 63 of the judgment. And you'll see that the paragraphs of the affidavit said to constitute waiver are paragraphs 27 and 29. Just to put that into context, if you can just have a look at bundle 3, tab 3. You'll see the Chief Justice has referred to paragraphs 27 and 29, but not referred to paragraph 28. Which was,
So which paragraphs are we looking at?
so paragraphs 27 to 29 are the ones
Yes.
the Chief Justice refers to as
Yes.
constituting the waiver. You'll see their terms set out there. But what I was drawing your attention to in addition was paragraph 28, where the deponent makes very clear there's no intention to make any waiver of privilege in making those references. And you'll see from paragraph 27 what is said. The documents identified in Hurrion's letter mirror the documents sought by the plaintiffs in the discovery application and the further request, and requested the specific documents and categories and documents set out in that letter. And sorry, at the top of that it says the defendant made a further request to the bank for the classes of documents specified. So that's all that's said in paragraph 27. And paragraph 29, you can see the bank responded and provided further documentation and identified the documentation. So essentially what you have here is a request for specific documents, a response enclosing the documents. In addition to those paragraphs, you've also got a letter.
Would you forgive me?
Sorry.
Could you forgive me a moment? I need to deal with something about it.
Of course.
Oh, thank you so much. I hope so. Yes. Sorry about that.
No, not at all.
Yeah.
So I was going to take you to the other document the Chief Justice refers to, which is a letter written by Appleby on the 2nd of July of 2019. You find that in bundle 4 at page 464, looking at the black numbers, not the red numbers.
Sorry, could you give me the reference again? Tab 4.
Sorry, I apologize, I didn't give you the tab number. It's bundle 4, tab 2, and then page 464.
Thank you.
And you'll see that on the second page, page 465, there's a heading, all documents evidencing transactions carried out on the relevant accounts. And then you'll see in the second paragraph, it says CS Life has made requests to the bank for documents in these categories previously, including a further request Appleby making to the bank set out below. Any responses thereto for the avoidance of doubt legally privileged, for the avoidance of doubt legally privileged, and CS Life does not waive the privilege in those documents by referring to them, and disclosed the relevant and non-privileged documents provided by the bank to the plaintiffs in its first and second discovery lists. And then in the following paragraph, an attempt to allay the concerns and consistently override the objective, we've made a further request of the bank for documents. that request seeks any documents falling within the classes. So that's the extent of the alleged waiver. The law in relation to waiver is, to a certain extent, straightforward. And you can see
Sorry,
that.
Mr. Morris, what about your client's response to this letter?
Well, the paragraphs I've identified are the ones that the learned judge has relied on in saying there's been a waiver. In terms of so the letter is a letter written by my instructing solicitors. So it's their letter.
Right.
And they're basically detailing what they have done,
Yes.
in response to the request by Hurrion. So I was going to take you to the authorities in this area. So first of all, you've got tab 18, which is the case of Government Trading Corporation and Tate and Lyle. And the issue that had arisen in this case is whether or not the right entity had been sued by Tate and Lyle. There's one company called Foreign Transaction Company and another one called Government Trading Corporation. The question is, had they sued the right one? And then you can see on page 2, about halfway down, it says, after the evidence was called, a question arose concerning the evidence to be given by Mr. Patton, solicitor acting for Tate and Lyle. And then you can see he filed an affidavit. And it's quoted from at the bottom of page 2. And you can see where it says 8, a whole series of facts are set out by reference to what the Foreign Transaction Company was and what it did and so forth. And then over onto page 3 at the top, you see at the end of that provision of information, Mr. Patton said, the information contained in this paragraph is derived from a firm of lawyers practicing in Tehran, whom my firm has consulted, and I believe it to be correct. And then you can see that counsel for the defendant, who had wisely instructed Lord Mance, took the point that amounted to a waiver of the legal professional privilege that would otherwise have attached to the advice being given by the Iranian lawyers. So that was the point that was being taken. And then over the page at page 4, Lord Justice Goff says, looking at the second paragraph, in the middle of the second paragraph, the question is whether, having regard to the circumstances in which Mr. Patton came to swear paragraph A to the affidavit, and as to what's deposed to, this constitutes a disclosure of a document or communication which amounts to waiver of privilege, whether it is what has been called in the authorities a mere reference to a document or conversation which doesn't amount to a waiver of privilege. There's then a reference to the case of Infields and Rosen and the judgment of the Master of the Rolls in that case. And in particular, there's a reference to a passage in the affidavit in that case, where the affidavit said there's furthermore been disclosed by the plaintiffs a bundle of documents for which privilege has been claimed by them, which trace the history of the development of the various clip designs supplied by the firm of Carl Beef to the plaintiffs, which are quite inconsistent with the defendant's said allegations. The learned Master of the Rolls, however, held this didn't amount to a waiver of privilege, but was simply what he called a reference to a document. referred to the fact that if, for example, a document is referred to in a pleading, the other side could apply to the court for production of a document. If so, the parties referred to the document in his pleading may prefer to withdraw his pleadings rather than produce the document. And then it goes down, for present purposes, the point in the Master of Rolls judgment is that he draws a clear distinction between the mere reference to a document and a waiver of privilege in respect to the document. And then in relation to the case that was before Lord Justice Goff, he says this: in my judgment, in the present case, the only judge was right to hold that the passage in Mr. Patton's affidavit was no more than a mere reference. Mr. Patton was making reference, as I've said, as a basis of his submission that there was not an appropriate case for a preliminary issue. I said he was going to be an issue about a particular paragraph in an Iranian law, and that was going to be evidence about certain facts in relation to the effect of that paragraph. Mr. Patton was there doing, as I read it, the same as Mr. Infields had done in the case to which Sir Wilfrid Green gave his judgment. And these are the important words. He was referring to a certain matter, he was setting out the substance of it, and he was, I fear inadequately, giving the source of information. I do not read that in the context of the interlocutory application then before the commercial judge as amounting to anything like a waiver of privilege. And so there you can see, referring to the content of the communication, in the Infields case, referring to what was contained in the documents, the history of the development of the various clip designs, and in this case referring to the advice received from Iranian lawyers as to the foreign transactions company. In relation to both those situations, the court held that didn't amount to a waiver, it's simply a reference. So that's that case. The next case is the following tab, Marubeni Corporation and Alafusus. And if you see over the page, page 2, this was another affidavit sworn by a solicitor. And if you look halfway down, Lord Justice Lawton says, here come the important words. An agreement in respect of the Dress Commission dated the 22nd of February 1984, which is said to bear upon the legality and enforceability of the contracts. The plaintiffs have obtained outside Japanese legal advice, which categorically states that this agreement does not render performance of the sale contract illegal in any way whatsoever. And then the question is, does that amount to a waiver, as Mr. G was suggesting? And this was an application for service out of a jurisdiction, as you can see from the paragraph below that. And then you can see what was said by Lord Justice Lawton at page 4, after referring to the two cases we've already had reference to, Government Trading Corporation and Infields. He says, in my judgment, the same principle applies here. All the deponent was doing was saying, well, I'm asking the court to allow service out of a jurisdiction. I'm being frank with the court. I've received certain information from Japan. I believe it provides no defense to the defendants. In other words, he was not relying on the contents of the document. He was relying on the effect of the document. He had to refer to the Japanese lawyers because he was under duty to give the source of his information. He could only do so by referring to what they had told him. So there you have a further component that you can describe the effect of the document, and that equally doesn't amount to waiver. And then you've got Lord Justice Lloyd in the same case, where he says the judge held that there had been a waiver of privilege in relation to the document on the ground that the document was one on which the plaintiffs were placing reliance. But with respect, that's not the right test. It cannot often be a case in which a document is referred to in an affidavit in interlocutory proceedings on which no reliance is placed. If therefore reliance on the document is in every case an implied waiver, and that would indeed have very far-reaching consequences. It would mean, as my lords pointed out, the defendant in Order 14 proceedings who refers to the advice of counsel, if he has a good defence to the claim, would be waiving privilege in that advice. That cannot be right. And then at the bottom of the page, Mr. Hamilton submitted before us that the true contrast is not between a mere reference to the document in the affidavit and reliance on the document, which is a contrast which the judge drew, but between a mere reference to the document and a quotation of its contents. I agree with that submission. Mr. G seeks to support the judge's judgment on the ground. There was here more than a reference to the document. There was a reference to the contents of the document. There is no distinction, he submits, between reference to the contents of a document and verbatim quotation from the document. But I would not accept that here was a reference to the contents of a document, and certainly no verbatim quotation. There was a reference to the effect of the document, which is a very different thing. And so you can see what Lord Justice Lloyd was working towards was the fact there needed to be a quotation.
Yeah, I follow this. It's slightly odd when it's suggested that there wasn't a reference in this case to the content of the document, because if you go back to page 2,
yes.
What was being said was the plaintiffs have obtained outside Japanese legal advice, which categorically states that this agreement does not render performance of the sale contract illegal in any way whatsoever. Sounds rather like the content of the document to a first time reader.
I would agree with your lordship. You might have thought that would result in the court concluding it had been a waiver because the contents had been referred to,
Yeah,
and indeed relied on. But that's not the consequence that the Court of Appeal decided should follow.
Quite. But they appear to have done so on the basis that there wasn't a reference to the content, which strikes me as slightly odd.
Well, I think if you look at Lord Justice Lloyd,
yes,
he seems to be saying that one needs, on the basis of a specific reference to the content, because he says I wouldn't accept that here was a reference to the contents, and there was certainly no verbatim quotation. So the reference obviously needs to be a fairly detailed reference before it falls foul of a rule, appears to be what Lord Justice Lloyd is saying. And certainly, if you look at Lord Justice Lawson at page 4, that passage I took you to,
yeah.
He again says he's not relying on the contents, relying on the effect. Well, if you can go that far, and that can simply be relying on the effect. In our case, we're miles away from it.
And it is slightly odd to find that if a solicitor or a party says, I wrote to somebody asking for the documents that you asked me to ask about, you being the opposing party, and he produced these documents, that is somehow a waiver of privilege, if there is any privilege. What's the basis for the claim to privilege? I mean, if you write a letter saying, have you got the following documents, and get a reply, how is that privileged?
The communication between the bank and the defendant in relation to documents is part of the litigation privilege, because it involves the collection of material and documentation for the purposes of the proceedings.
Yes, I suppose so.
Well, the next case is the Dunlop case, which is at tab 25. This was a case involving Dunlop and whether or not there was, I think, passing off, and a slight issue about the computer that the defendant had and whether it had been tinkered with, and the situation developed such that a forensic expert was appointed, and what the forensic expert did made its way into a witness statement produced by a Miss Ahmed, and you can see that from paragraph 7. But the issue was, what had the forensic expert done, and she there describes what he did at a meeting. And then if you go down to paragraph 10, the question is, did JBSL waive privilege in at least part of the communications? Was then a reference to Matthews and Malik, which we haven't looked at before. This is a passage that was relied on by my learned friend, and it indeed is picked up in the judgment at paragraph 61.
Where's that passage?
The passage is it's actually a passage that's cited elsewhere, because the Brennan case, which is the case that follows, cites this passage. So you get a sort of double reference to it. If you look at the Brennan case refers to this passage, and this passage in turn refers to Matthews and Mallock. But I was just taking the court to this because this is where it originates.
Oh.
And essentially it identifies the cherry picking aspect, namely you can't give half, you can't rely on half your advice without disclosing the rest of it, essentially, which has no real relevance in our respectful submission to the situation that's before the court. But you see at the end of paragraph 11, the judge concludes, so it is that the authors correctly identify that the authorities provide for a distinction between a reference to the effect of the document and reliance on the content. Mr. Crawford suggests this is a reference case and a deployment case, and the judge then finds it's a deployment case. Miss Ahmed was seeking, this is paragraph 12, Miss Ahmed was seeking to refer to the contents of the information that were being supplied by the expert to her in order to seek to persuade Mr. Justice Gibbs to make an order that the further evidence should be allowed to be put in. And then he says it's further defined in a different sense as an attempt to put evidence in for the purpose of the trial, and so on and so forth. And then paragraph 15, he refers to the cherry picking rule. And in paragraph 17, he says there has been a waiver, but a limited waiver. If you look at the bottom of page, so I'm not sure the page is numbered, but the penultimate page in paragraph 17, he says the judge made too wide an order but came to the correct conclusion. The relevance of that is this, that in our particular case, as you can see, there was a reference, I think, to two documents. What the Chief Justice has ordered is disclosure of all correspondence between the defendant and the bank. So in essence, requiring everything to be disclosed that has ever been written in relation to discovery. Where plainly, if there has been any waiver, it's only in relation to the specific documents referred to. The next case is tab 29, which is the Brennan case, which is the one the learned Chief Justice was quoting from. He summarises.
Which reference is that? Where is that?
This is tab 29.
Thank you.
It's an employment appeal tribunal case. Argument about equal pay, and essentially with some council meetings. There was a claim against the council, and some council meetings which were various references made to legal advice. That's the background of it. Mr. Justice Elias, who was the president of the tribunal, deals with the relevant law at page 483 as he sees it. First, I just invite you to look at those principles set out at paragraph 16. And in particular reference to the principle of fairness. And then over the page, you can see he refers to the cherry-picking principle and position in relation to accidental waiver and so forth. And then paragraph 17, the principal issue in this case is whether there has been sufficient disclosure of the relevant advice that fairness requires that it should be revealed in full. And he then refers to the various references in the minutes of paragraph 18. And then paragraph 30 on to paragraph 45, he then refers to Dunlop and the Dunlop case, which you looked at, and there's the citation that I think my lord was referring to. And then he refers to the case that he's already looked at paragraph 47, described as benevolent view. And so you've looked at those cases, and the conclusion reached is at paragraph 64. Typically, as we've seen, the cases attempt to determine the question whether the waiver has occurred by focusing on two related matters. The first is the nature of what has been revealed. Is it the substance, the gist, content, or merely the effect of the advice? The second is the circumstances in which it's revealed. Has it simply been referred to, used, deployed, or relied upon in order to advance the party's case? As Lord Justice Waller observed in Dunlop, the principles are not altogether easy to discern, but partly perhaps because of the vagueness of the language adopted. For example, sometimes reliance and deployment are used as separate terms, sometimes they appear to mean much the same thing, and partly because the cases are necessarily fact sensitive. He then says, paragraph 65, it's an error to treat the earlier authorities as having the sanctity of statute. We would not therefore adopt in quite such stark terms the contents effects distinction which was submitted to them. Plainly, the fuller the information provided about the legal advice, the greater the risk that waiver will have occurred. We do not think the application of the waiver principle can be made to depend on a labelling exercise, particularly where the categories are so imprecise. The concepts shade into each other, do not have a precision required to justify their employment as rigid tests for defining the scope of waiver. Having said that, we do accept that the authorities hold fast to the principle that legal advice privilege is an extremely important protection and that waiver is not easily established. In that context, something more than the effect of the advice must be disclosed before any question of waiver can arise. And we would submit exactly the same in relation to litigation privilege.
Mr. Moverley Smith.
Yes.
We are referring to paragraph 3 of the order. Requiring, yes, documents of the bank. How do you say that any of these categories of documents comes within relevant advice as discussed in the case law?
So the paragraph 3 of the order is dealing with confirmation and the fact we needed to confirm that we had required the bank to produce various documents. The issue of privilege arises in relation to the court's finding, which is the first recital on page 1 of the order. And the consequence of that finding is that we are now, under the ordinary requirements of discovery, obliged to give discovery of the correspondence. So I think it arises in that way and not under paragraph 3.
But they are of the same kind of documents, are they? Attendance notes, call records, documents, evidence and transactions, and so on.
So the documents listed in paragraph 3 are the documents, the historic documents that deal with the transactions that took place on the relevant investment accounts.
Yes.
So those are all relating to that. Whereas, so paragraph 6, I think, is the one that operates in conjunction with the first recital.
I see.
Can I be clear, Mr. Moverley Smith, please? Are we, and I've just been printing out for myself the letter, what documents are we actually referring to, or was the judge referring to in relation to this privilege issue?
The paragraph he identifies as amounting to waiver is the one on page 465.
Sorry, can you tell me by reference to the 262 numbers, just that my printer
Oh, sorry,
has-
it's page 262 in red on my bundle.
Yeah, yeah,
And the judge is referring to the section headed all documents evidencing transactions on that page.
yes, yes,
And is referring to he refers to all those subparagraphs under that heading, but I think he is intending to identify the fact that we say requests have been made to the bank for documents.
Well, what I'm not clear, and I'm following on from my Lord's question a moment ago,
Yes.
is the issue about whether the documents are privileged relating just to CS Life's requests to the bank and the bank's answer?
Yes.
Or is it relating to the actual documents in the
No,
heading as underlined?
No, it's only in relation to the correspondence between the bank and the defendant. So it's that correspondence, which is the correspondence to which litigation privilege attaches. It's not, no, the underlying documents, the historic documents are obviously not subject to privilege, and we wouldn't suggest they were.
Well,
So-
just help.
Sorry, you go.
No, you go. You go.
So when one goes on in the letter at page 266 in red,
Yes.
and we see the third paragraph down, those requests and any responses thereto are for the avoidance of doubt legally privileged. It's back to the second page of the letter, is it?
Essentially, they're the same request, yes.
And where it says,
You can see the same formula repeated in relation to the other headings.
yes. So it's just those requests. I see. Thank you very much.
Okay.
But can you? I'm slightly puzzled as to the form of the order,
Yes.
because the recital in the second recital says, upon the court finding that privilege has been waived in respect of the defendant's request that Credit Suisse produce documents in relation to the discovery in this action, referred to in Appleby's letter of the 2nd of July and in the third affidavit of Thomas Coffey, and any responses received from Credit Suisse thereto.
Yes.
On one reading, that is referring to a waiver of the requests to the bank referred to in the letter of the 2nd of July and the third affidavit, and any responses to those requests, not to every request that CS Life has ever made of the bank.
I think, I mean, your lordship may be right, and maybe it's unclear, but paragraph 6 refers to copies of all correspondence.
Well, I'm afraid that has its own problems, because it says by 4 p.m. the defendant shall provide the plaintiffs with copies of all correspondence between the defendant and Credit Suisse, in respect of which any alleged privilege has been waived in relation to the defendant.
So it feeds back into the first recital, as your lordship rightly says, yes.
Well, yes, I mean, in respect of which any alleged privilege has been waived could mean all correspondence between the defendant and Credit Suisse in relation to disclosure is correspondence in respect of which privilege has been waived,
or it could mean the defendant shall provide copies of such correspondence between the defendant and Credit Suisse, in respect of which privilege has been waived, being the correspondence being the waiver referred to in the second recital.
Yes. I mean,
You understand?
Yeah,
You've taken it to mean.
Yeah. I understand this to be a finding that we waive privilege in relation to all correspondence.
I see. Okay.
And not simply what has been referred to. I mean, I think in relation to what has been referred to, what's said in the letter is that CS Life has made requests to the bank. So that on the face of it is undefined and therefore arguably covers all requests made to the bank. But of course, that's an even looser reference than what's stated in the affidavit. It doesn't actually say what was the nature of the request and which requests related to which category of documents. So it's even less clear in terms of content.
So on that basis, if you write a letter which says, we have, of course, made a number of requests to the bank. In particular, we have requested the documents referred to in your letter of such and such a date. And we've got the following back from the bank. On your analysis of what the judge intended to find, there has been a waiver of privilege, not merely in relation to the request for the documents referred to in the letter, but every request, because of the first paragraph of my putative letter, which says, you realize, of course, that we've made a number of requests to the bank.
Yes, that seems to be what the judge has ordered.
Might be thought to be counterintuitive, but there we are.
Yes, well, that sort of highlights the issue we have with how the learned judge approached this.
Right.
The next case, and I've only got two more pieces to say, but next is tab 37. And this is a decision of Mr. Justice Morgan in 2014. This was a passing off case. And if you look at paragraph 3 of the judgment, Mr. Justice Morgan says, what's caused the present application to be made is that Miss Petty has 2 paragraphs in her witness statement where she gives evidence as to the circumstances in which she has come forward as a witness. And the paragraphs are set out. In December 2013, I was asked by my colleague to notify of any examples I'd encountered of customer confusion. I informed her of an incident which had occurred the same day. So that's those are the paragraphs. Then if you turn to paragraph 10, there was acknowledgement those paragraphs are subject to litigation privilege, but they were saying that communications had been partially opened, so opened up, and the law is that if one opens up part of privileged communication, the court can insist on the entirety of communication being disclosed. And then over the page, there's a reference to paragraph 13 to Brennan, which is the case we just looked at. Where he says, when deciding as to the extent of their waiver, one should look at the nature of what's being revealed. This was a case concerning legal advice privilege rather than litigation privilege. In that context, it was said, is what has been revealed the substance of the advice, the content of the advice, or merely the effect of the advice? And the second matter, a relevant matter, concerns the circumstances in which the disclosure has been made. Has the revealed matter been deployed to advance a party's case, or has it simply been referred to in a way which falls short of reliance and deployment? And then you can see the analysis, paragraphs 15 to 17. In paragraph 16 in particular, it seems to me all that has happened in paragraph 2 of Miss Petty's statement is that she's identified the fact of the communication and the subject matter of the communication. Beyond that, she does not go. was no attempt to refer to the content of the communication beyond its subject matter. And of course, that's exactly our position. The subject matter of the communication is a request of a bank for documents. And we've gotten no further than that. And he makes the same point in paragraph 17, what is disclosed, the last sentence, what is disclosed as a fact of communication, the subject matter of the topic of the communication, but not the content of the communication. And then finally, and most recently at tab 43, was a decision of Judge Jarman sitting in the High Court in April of this year, a TMO case. And this was a case where Mr. Philip Duffy, the well-known liquidator, had been appointed and over a company administration. And the company suggested that he hadn't had any proper belief that the value of the business assets were 1.235 million 3 years before. That's what you can pick up from paragraph 7. So essentially, what was being suggested was that Mr. Duffy had essentially been making an untrue statement in relation to the value of the business. Mr. Duffy didn't like that, and he filed a witness statement, and the contents of that are set out in paragraph 8. And you can see the question turned on what valuation had been produced by Ernst & Young. And halfway down that paragraph, he says, EY's valuation used Rebio as a proxy for TMO on the basis that Rebio is a company exploiting TMO's assets, having acquired them out of administration, without waiving any privilege in the report which EY prepared. Using a discounted cash flow methodology, EY carried out a valuation of TMO in a range of different scenarios. The figure of 19.5 million is derived from that valuation. Yeah, sorry, I said earlier 1.235 million. It should have actually been 19.5 million was the relevant figure. So Mr. Duffy was justifying the stance he had taken by reference not only to the report but also to what the report referred to and the calculations contained in the report. The question was that a waiver or was that mere reference? And you can see the judge's conclusion. He makes reference to the principles at paragraph 21. And then paragraph 41 to 44, he says, paragraph 41, the reference was made for the narrow purpose of rebutting the allegation liquidators could not possibly believe the pleaded quantum. And the Deputy Master's failure to take into account that the report was obtained for pleading purposes only was not intended for use at trial. This should have been clear to the Deputy Master. Then was a reference to the various points of argument being raised. And then over the page, paragraph 43. In my judgment, the Deputy Master should have taken the points set out above into account. Had he done so, there would be no justification for his conclusion that deployment of part of the contents of the EY report went to the merits of TMO's case. Moreover, there was no justification for the conclusion that any reference to the report went further than merely rebutting the serious allegation that liquidators couldn't possibly believe the pleaded quantum. So if there's anyone trying to rely on the contents of the report, it was, on the face of it, Mr. Duffy, who was trying to justify his conclusion by reference to what the report contained, and yet that was not viewed as a waiver of privilege.
Could you explain to me why these requests are subject to privilege anyway? Why your clients say they're privileged documents?
But they're privileged because they're part of the litigation process. They have being created for the purposes of obtaining information which is to be used in the litigation, in the same way as communications between the client and his solicitor or solicitors and third parties gathering information for the purposes of litigation is subject to litigation privilege. And the same is the case here. I mean, the position in relation to that is that Mr. Hollander at one stage suggested they weren't subject to litigation privilege, but then proceeded on the basis that he was prepared to concede for the purposes of the application that they were. And that's why we had the argument about waiver.
Yeah.
And I think that's all I wanted to say about waiver, unless there's anything further I can assist in relation to that. But I've made the point that if there is waiver, it could only be in relation to the very specific documents referred to, and not more generally.
Well, that might seem a convenient moment for us to take our mid-term break, our mid-case break.
Just to tell you how I'm getting on, I've just got to do with the deal with the Swiss Code of Obligations. That's largely a question of looking at the one judgment produced by the tribunal. That's relevant. So I hope I won't be too long doing that.
Good. Okay. Well, you'll tell us the difference between internal and purely internal in due course.
Delighted to.
Shall we? What time is it now? Shall we resume at 4:45 in English terms?
Yes,
Can I just mention, I'm going to try and go home now because I know my laptop at home works. I hope to be able to get there in that time, but I might be a couple of minutes late, unless that would cause the court inconvenience.
Well, it only causes the court. I mean, we are going to finish this case today, are we not?
I certainly hope so.
I certainly hope so too. It would. I mean, we don't want to find that you haven't got home in time and there's some delay, and therefore we don't finish today. We can't.
I'm happy to stay and not go home. I just thought I know I have a camera there that works.
Well, how long does it normally take you to get home?
No, I would hope to be there in just over half an hour.
And how are you going to get there?
Well, I'll either get a cab or get a tube, whichever's quicker.
Well, all right.
Well, if you prefer, I'll stay here. It's just there won't be a camera.
I think it would be quite nice to see
Yes, it would.
Mr. Hollander.
Yes, I think you should go extremely swiftly.
Yes, I'll do that now.
We'll start again at 4:45 English time, or so near there too as we can safely get.
Right.
Okay. Right. I'm going to go to our breakout room.
That's bad. Thank you.
Mr. Coelho? Can you hear me? Oh, I think you're still on mute.
Yes.
Hi. Sorry, it's Miss Tildesley from Appleby. I just wanted to double check. I can see that the proceedings are live on YouTube. Once we're finished, will the video become immediately available on YouTube to be sort of rewatched? Because if it will, then we can get our transcribers onto the transcription very quickly because they can just watch it on YouTube.
That is correct. And actually, that's not a bad idea.
Okay, that's great. I just wanted to double check that you didn't need to edit it or something like that. I assumed it would go straight up, but
yes.
That's great. Okay, thank you ever so much. Appreciate it.
No problem. Good afternoon.
Good afternoon.
Mr. Moverley Smith, Mr. Hollander, are you with us?
Can you hear me?
Yes.
Can you hear me? Oh, I'm hoping we're going to have a picture as well in a moment.
Are you talking to me from your laptop?
Yes, I am.
Okay.
So I can't start my video because Hey!
There you go.
Gosh, fantastic. Sorry to cause everybody so much inconvenience.
No, not at all. I'm just going to leave this area and go into the judges' room to let them know we're ready to start.
Okay.
Good to see those at Appleby socially distancing, although one only has their mask on.
You encouraged them to mask up.
Are you in England, Stephen?
Yes, I am. Yes, East Sussex.
Well, now we can see you, Mr. Hollander.
Yeah, I'm sorry about the inconvenience.
No, don't worry. Well done for getting back in time. Right, are we all, oh no, we're not all here. Right, now what's happened to Mr. Moverley Smith? He seems to have disappeared.
No, he's here.
He's
Oh,
there.
he's there. I'm so sorry. Yes.
Up the top.
Right, okay. No. Right, let's go on.
Okay, thank you. Yes, I was going to move on to the Swiss law point. It's Article 400 of the Swiss Civil Code of Obligations. And just so you're aware of what it says, if you've got bundle 6 to hand, it's tab 1 of bundle 6. And you'll see it provides that an agent's obliged at the principal's request, which may be made at any time, to give an account of his agency activities and to return anything received for whatever reason as a result of such activities. So there are two aspects, the first of which is to give an account of his agency, and the second is to return anything received.
Yes.
And we're concerned with the first of those duties, the duty to give an account.
Yes.
The position reached between the experts was essentially that they accepted that Article 400 applied to the relationship. They accepted there was an obligation to produce documents, which included internal documents. There was a dispute as to whether or not excluded from that category of internal documents were what's been termed as purely internal documents. So you've got a very narrow compass to consider. you have the evidence of Professor Pinachas on behalf of the plaintiffs, which was it was only one test, which was relevance. So the only question is a document relevant? If it's relevant, it's disclosable. There's no separate category of purely internal documents. And Dr. Dalefio, who was the defendant's expert, took the opposite view. And the other thing to note is it was common ground that the question turned on a single judgment of the Swiss Federal Tribunal, case 139 in 2012, which I'll take you to in a moment. In terms of the expert evidence, while there was some footnotes in both expert reports referable to legal commentary, none of that was produced to record, and only a very limited number of cases were referred to. The only relevant ones are the ones in the bundle in bundle 6. What the learned judge decided was he preferred the opinion of Professor Pinachas by reference to his analysis of the 2012 judgment and by reference to a case in 2019.
Yes.
There was no analysis by the Chief Justice of the underlying evidence of either witness, their testimony, and there's no reference in the judgment to any of the transcripts. The testimony was essentially the witness's own interpretation of the words used by the tribunal. And as I said, only strayed beyond that, but Professor Pinachas referring to the 2019 decision, and Dr. Dalefio referring to a decision in 2014, which I'll take you to. So in terms of the scope of the evidence, it was very limited. The cross-examination is available in the transcripts, but it doesn't really take matters very much further forward. In terms of the principles, I think I need to take you to one case, which is at tab 23 of your, pardon me, of the authorities bundle.
Can I just understand this, please, Moverley? What is being said is that the bank was agent of the defendant, is that right?
Yes. Essentially,
just explain that.
Yes, of course.
Construct to me.
So the defendant's a life company.
Yes.
The bank acted as its agent. The life company took a premium off the plaintiffs, which was the bank, and the bank therefore was the defendant's agent in relation to that investment. There were various agreements, but it was the experts agreed that some consequence of those agreements was that a duty under Article 400 arose. So the actual terms of the individual agreements didn't become, in the end, relevant.
And what was the bank doing? The bank was managing the money, was it, basically?
Yes, so the bank, essentially what happened was that the plaintiffs were customers of the bank and had been for a long time. It was suggested to them that it would be advantageous for them to use the wrapper, as it's called, of a life policy in order to part of their investments through insurance premium into an insurance policy. And the policy provided for them to redeem the policy by reference to the increased value of the investment.
Yeah, absolutely, in the normal way.
Yeah, so that's what was going on. The agreements were governed by Swiss law because obviously the bank's Swiss. And the question is, what was the duty of the bank as agent of the defendant under those agreements, which was governed by Swiss law? And as I said, it was common ground that the consequence of those agreements was that an obligation arose under Article 400 to account. And that's how we get to where we are.
Who was the insured under these policies?
The insured, the two policies, and the insureds are the fifth, sorry, I got the numbers right. It's the
two companies, are they?
The seventh plaintiffs. So the sixth and seventh plaintiffs were essentially companies that belonged to the trust, and they took out the policies. So they're the policy holders. I'm sorry.
What were they insured against? What were they insured against?
It was a life policy.
Whose life?
So it was the first plaintiff's life,
Right.
and on his death, the policy matured. But there was a
Yes,
provision for surrender and partial surrender.
Oh.
So essentially, you could take the money out of the policy as and when you wanted.
Oh, I see. Thank you. Yeah.
And as I say, we're in Swiss law because the agreements were governed by Swiss law, and everyone's agreed Article 400 applies.
Yes.
In terms of when the Court of Appeal can interfere with a decision made by a judge in relation to foreign law,
Well, it's
obviously,
fact, isn't it? I mean, it is fact.
exactly the point. Yes.
Yeah.
And you could say, well, it's a finding of fact, and therefore the judge's view should, in most circumstances, be preferred. However, the findings of fact in relation to foreign law are taken slightly differently. And you can see the approach of the court in relation, Court of Appeal, an appellate court, I should say, in relation to foreign law findings in the Macmillan case, which is what we have at tab 23. You recall as part of the Maxwell unwinding. There's a claim by Macmillan against Bishopsgate Investment Trust. There was a question of US law involved in that, and Lord Millett made some findings about US law, and the question was, could the Court of Appeal interfere in relation to that? And the Court of Appeal very helpfully at paragraph 9 in the judgment of Lord Justice Evans explain the principles under which the Court of Appeal can interfere. And what I was going to do is just invite you to read from paragraph 9 through to, I think, paragraph 20 is probably as far as you need to go. And I particularly focus on the paragraph cited from Mr. Fenterman's book at paragraph 18. Where it says appeals are readily entertained for findings on foreign law. This may lead to a thorough re-examination of the evidence, including transcripts of the oral examination of the parties' experts at trial. Certainly, appellate courts are willing to engage in such a review, no doubt because it affects the legal rights and obligations of the parties. The more an issue of foreign law depends on matters of expert testimony rather than construction, the effectiveness of the appellate review diminishes.
Yes.
And so the position in this case is that you have opinions expressed which are only really questions of how you construe the expressions of the federal tribunal. So it's simply a question of what the federal tribunal may have meant by what it said. As I say, there are only 2 cases referred to which appear to touch on the point. And neither case at the end of the day is directly relevant. So it's a very small compass. And as I say, neither expert pointed to any other matter other than the defendant's expert, Dr. Dallafior, was able to give a limited amount of evidence about his own experience. He was a practicing lawyer, whereas Professor Pichonard was obviously an academic. And I'll take you to that in a moment. But perhaps if we could start by looking at the federal tribunal judgment. And that should be the new document you've got. So
Where do I find that in your skeleton, please?
if you look in our skeleton, we refer to the relevant parts.
I'm just wanting
At
to.
paragraph 60, yes, of course, yes. At paragraph 64,
Yeah.
and I think we set out most of the relevant part of the judgment there.
No, that's ATF 139.
Yes, unfortunately, the way they describe cases in Switzerland is less than helpful. And you notice that this particular document describes it as DFT 139.349.
Sorry, which document are we looking at?
So we're looking at the copy of the Swiss judgment that was sent through yesterday to the court. So it's not in the bundle. It's the one I mentioned at the start. Yeah, do you recall at the start of this hearing I mentioned that?
Yes, I do recall that. But when you say it was sent through, where am I supposed to find it?
It was sent through, as I understand, to Mr. Quallo yesterday.
Have we got it, Quello?
I'm just looking on the cloud. What is the name of the document?
It says it should say Transperfect Certification. It should be Judgment 139 Roman 349 should be the reference.
It's the agreed translation, is it?
Yes.
That's on the cloud as agreed translation.
Yes, that one. Yes. Thank you.
Well, you say that.
It is there. It is there as agreed translation.
Why do we have to? Why are we using what wasn't the translation in front of the judge?
No, sorry, my lord, the position is that this translation was in front of the judge. The other translation was as well, but we agreed for the purposes of the hearing that we would rely on this translation, the one in the cloud. And unfortunately, when the bundles are put together, the translation that was put in the bundle was the other translation. And so all we're really trying to do is to remedy that position by giving you a further copy of the judgment.
Okay.
I'm very sorry about that.
Distinctly unhelpful.
Lord, as I say, I do apologise.
Okay.
So if I can take you to that, and I'll do it by reference. If you look at the pages, they've got in the middle of each page a page number. And if I do it by reference to that to help you through the judgment, I hope that's convenient. So looking at internal page 49, you can see that this was a contractual relationship based on a master agreement for OTC transactions and call and put options, foreign exchange, so banking transaction. And then if you turn through to paragraph 4.1.1, you can see that what was being asserted is that internal documents were in principle neither subject to disclosure
I'm
nor
sorry.
to accountability.
Mr. Moverley Smith, you now make reference to paragraphs.
Sorry, paragraph 4.1.1.
That's not
I think
page
on the
53,
internal
is it?
page, sorry, I do apologize, on internal page 53,
Yes.
just at the very bottom of that. And you can see what was being said was that internal documents in principle neither subject to disclosure nor to accountability. So in relation to those two duties we saw under Article 400, it was being said that internal documents weren't subject to either duty and therefore no obligation to disclose them. And then it goes on. When it says addition, it means essentially a compilation or proof of internal documents had been ordered under the cloak of accountability, which undermined the protection of the agent, they said, which was carefully delimited in the context of a duty of surrender. And then we can read, I think, down to 4.1.2. According to Article 400, paragraph 1 of the code, the agent has to give an account of their management at any time upon request and to reimburse everything he has received as a result of it for any reason. The accountability of the agent should enable the principal to control their activities. It forms the prerequisite and basis of the obligation to deliver or surrender. Like accountability, the duty to deliver is a central element of the external value of the contract. The obligation to surrender in accordance with Article 400 can also be understood as a specification of the duty of loyalty in accordance with Article 398. And then down to the 413, the scope of accountability.
Before you go on, I just want to follow. Are the words to be emphasized at the beginning of 4.1.2? Upon request and to reimburse everything he has received as a result of it for any reason.
Yes. So that's the second part is the obligation to surrender or deliver up.
Yes.
We're really concerned with the first part, which is the duty to give an account. And then down to paragraph 4.1.3. The scope of accountability is limited to matters relating to the contractual relationship, whereby the agent must inform the principal fully and truthfully and submit to them all documents relating to the transactions carried out in the principal's interest. The obligation to surrender includes everything that's been handed over to the agent by the client or received from third parties in execution of the mandate. And then it says this: exceptions are purely internal documents, such as preparatory studies, notes, drafts, material collections, and own accounts. Now, those words in our submission are clearly an exception to the scope of the duty of accountability.
No, it says the obligation to surrender includes everything that's been handed over to the agent or received from third parties. When it says exceptions, that must surely be exceptions to the obligation referred to in the immediately preceding sentence.
Your Lordship has taken, I guess they're taking words out of my mouth. I was going to say, one might have thought that, but then one sees that what they are talking about are not documents that would have been received by the agent from the client, and they're not documents that have been received from third parties in execution of the mandate. So they're a totally different class of documents. And so therefore they can't be an exception to the documents that are subject to the obligation to surrender. And you can see that that's correct if one goes to bundle 6 for a moment at tab 7. There's another decision of the Federal Tribunal. You can see at paragraph 5.3.1 in this decision the Federal Tribunal revisits its decision in ATF 139349. You can see it at the bottom of paragraph 5.3.1, or sorry, the bottom of the first paragraph of that paragraph.
I'm sorry, which tab are we looking at?
So sorry, we're in tab 7.
Tab 7.
Oh, yes. And we're looking at the decision of the Federal Tribunal in 2017.
Yes.
And what I was pointing out to your Lordship is that if you look at paragraph 5.3.1, the Tribunal is referencing the judgment we've just been looking at, 139.349, and summarising what that judgment says. And with that in mind, if you then look at the beginning of paragraph 5.3.1, you can see what's said is to meet its accountability obligation, the agent must inform the principal in a complete and truthful manner and give it all the documents relating to the matters dealt with in the latter's interest. Exceptions are purely internal documents such as preliminary studies, notes, drafts, material collected and accounting. So those are the same words that we've just seen in the judgment we've been looking at. And it's for that reason, in our submission, it must be a reference back to the scope of accountability. So if I can take you back to the judgment 139, and we've got to the second part of paragraph 4.1.3 and the exceptions. The paragraph then continues as follows. The complainant relies on a doctrine according to which accountability as a complementary right to information cannot go further than the obligation to surrender and is thus subject to the same restrictions. So essentially what's there being said is that you can't get more from the obligation to surrender, sorry, the obligation to account can't provide more than the obligation to surrender. And that doctrine is one espoused apparently by someone called Stefan Hafner in a treatise called The Accountability of the Agent. And then they say this opinion is not to be approved. Although the Federal Supreme Court has ruled with regard to accountability that purely internal documents such as draft contracts that have never been sent are not subject to it. So there you can see a reference to the duty of accountability and the fact that purely internal documents are not subject to it. Sorry. Can I just give it a telephone on this one? I do apologise for that. It was unexpected. Sorry, I was saying at the top of the page, internal page 55, the sentence that says this opinion is not to be approved. And then I was making a point that the Federal Tribunal was referring back to its earlier decisions, Federal Supreme Court and Federal Tribunal, the same entity, and saying it's also ruled with regard to accountability, but purely internal documents such as draft contracts that have been sent are not subject to it. So therefore they are creating an exclusory category of documents that are not subject to the duty to account. But then they make the point, it can't be concluded from this that disclosure and accountability are of equal importance. For example, records of customer visits and contacts may be subject to accountability, although such internal records are generally not subject to the obligation to surrender. So what they're saying there is that in relation to internal documents, there can be an obligation to account for them. But that, of course, is still subject to the earlier exclusion of purely internal documents. So that's created this second category of documents. And the reason why internal documents that aren't purely internal are subject to a duty of disclosure is then explained. This follows from the purpose of accountability. Unlike the duty of disclosure, which guarantees compliance with a duty of loyalty, accountability is intended to enable control over the activities of the agent. And then they say at the bottom of this paragraph, from the fact that certain documents are not subject to the obligation to surrender, it cannot therefore automatically be concluded, contrary to the complainant's view, but no account is to be given of them either.
Could you tell me which paragraph you're on, please?
I'm looking at the bottom of the paragraph we were looking at a moment ago on
Well,
page.
can you give me the number? Please give me the number.
Sorry, yes, of course. This is still part of paragraph 4.1.3. And we've gone over the page and we're looking at the...
All right, thanks.
Because the paragraphs, you have sub-paragraphs that aren't numbered within the paragraph. I apologize. I wasn't making it very clear. And I was looking at the very last sentence of that paragraph that starts from the fact that certain documents are not subject to the obligation to surrender.
Just above the break at page 56.
Exactly, my lord, thank you. and then there's the paragraph that the Chief Justice focused on, which reads, a distinction must therefore be made between internal documents not subject to the obligation to surrender, the contents of which must be brought to the attention of the principal in an appropriate form in order to enable it to exercise any control over the activities of the agent, and purely internal documents, such as drafts contacts have never been sent, which are in any case not relevant for the verification of the agent's performance of the contract in accordance with the contract. However, the fact that an internal document is in principle subject to accountability doesn't mean it must be simply submitted to the contracting authority. Rather, in this case, a balancing of interests with the confidentiality interests of the agent must be carried out. So that's the key passage. And the difference between the experts was whether or not the words which are in any case not relevant for the verification of the agent's performance of the contract were simply describing a purely internal documents previously excluded, or whether they were saying that what are in the category of purely internal documents are simply irrelevant documents, and therefore the only test is relevance. And one of the questions raised by the plaintiff's expert was as to whether or not the comma made any difference. Because his conclusion was that the words after the comma, the words which are in any case not relevant for the verification of the agent's performance, were in fact governing the sentence, and therefore that they were identifying what were purely internal documents. And as to that, of course, there are a number of points that can be made. The first of which is, why would the federal tribunal be making a distinction between internal documents and purely internal documents if the only question was one of relevance?
But that assumes that they were making such a distinction. I mean, what is the difference between a purely internal document and an internal document?
Well, if I could just deal with the first of the points your lordship raised, they are drawing a distinction because they say they are. The first few words of that sub-paragraph are, a distinction must therefore be drawn between internal documents and purely internal documents. So they are drawing that distinction. What is within the category of purely internal documents might be matter for some debate.
Right. But they go on to give examples, and then the phrase follows, which are in any case not relevant.
Yes.
For the verification of the agent's performance, which suggests that relevance would condition whether or not they would be disclosable. But because they are not in any event relevant, they wouldn't be.
Well, I think, my lord, it's the other way round, that if there is a category of documents that are excluded, and as I say, there can't be any reason to create a category of documents if it's just a question of relevance. If there's a category of documents that are excluded, by definition, those documents won't be relevant to the question of accountability because they're not documents that need to be produced. And therefore, they're irrelevant to the exercise.
Wait a minute. I mean, one somehow feels one should credit the Federal Supreme Court with some nous. What they say is a distinction must therefore be made between internal documents, not subject to an obligation to surrender, the content of which must be brought to the attention of the principal in an appropriate form in order to enable it to exercise control over the activities of the agent. So yeah. There are internal documents whose content must be brought to the attention of the principal in order for the principal to be able to exercise control. That's category number one.
Yes.
And purely, let me finish. And purely internal documents, such as draft contracts that have never been sent, which are in any case not relevant for the verification of the agent's performance. So category number two is documents that are purely internal in the sense that they are not relevant for the verification of the agent's performance.
Exactly.
And it's exactly the example that was given in relation to doctors, because what they say in the preceding paragraph is the internal document the doctor writes, where he gives his notes on the medication that he gave to you, is not subject to the duty of surrender, because he doesn't receive it from the principal and he doesn't receive it from a third party. It is relevant as to whether or not he's been competent. Precisely the illustration given in the preceding paragraph.
Well, Lord, if that's right, the question then arises as to why the Federal Tribunal needed to draw a distinction between internal documents and purely internal documents.
No, well, you only take part of what they say. They drew a distinction between internal documents, which are necessary in order to determine whether the principal has behaved appropriately, and purely internal documents in the sense they are not relevant to that question, whether or not he's behaved properly, and are not subject to the duties of surrender, and are simply documents that the agent has, which he didn't receive from the principal and didn't receive from the third party and doesn't have to disclose in order to show that he behaved properly.
Lord, yes, but that's defining what is relevant for the. I think the problem is that what is relevant for the purposes of verification is defined by reference to what is, by reference to this paragraph, what is purely internal and what isn't. And they're excluding from the duty. They're not simply saying you need only disclose relevant documents. And there would be absolutely no point in making a distinction between the two categories of documents. Otherwise, it would be completely pointless, because obviously you'd only have to disclose things that are relevant in order to explain your activities. If something's irrelevant, by definition, it's not something you'd have to produce.
No. I mean, the question is, what does the duty of accountability require you to produce by way of documentation? To which the Federal Supreme Court gives the very sensible answer. The duty of accountability does not require you to produce documents that are purely internal, that is to say, have never been received from the principal or from the third party, and do not bear upon the question as to whether or not the agent has behaved properly. Those do not have to be disclosed, and in that sense, they are purely internal. They have no relevance to whether or not the principal had done his job. That is to be distinguished from documents which are internal, but do have relevance to whether the agent has performed his functions.
Well, Lord.
And if it were otherwise, we get the difficult position that according to you, and your expert, the Federal Supreme Court has made a distinction between internal documents and purely internal documents, the distinction between which I have asked you to explain already and have not followed.
In terms of a distinction, I think one has only got the examples given by the Federal Supreme Court,
Namely,
and which are identified as being preparatory studies, notes, drafts, material collections, and own accounts. And so they are saying on the page we looked at before that there are particular types of documents that are not part of the duty and therefore not relevant.
well, that may be so. I mean, assume that the agent is required to make a contract on behalf of his principal. He drafts a contract with third party X, and in the event no contract is made with third party X, that document may be wholly irrelevant to any question as to whether or not the principal has fulfilled his obligations. But assume that there is a set of correspondence between people at the agents when they're drafting a contract, in which one of them says, if you're going to have this sort of contract, you absolutely must put into it this clause, to which somebody replies, I entirely agree, of course I will do that in any contract of this kind. In fact, the agent enters into a contract on behalf of the principal and fails to include the vital clause. That is an example of internal correspondence, which would be manifestly relevant to whether or not the agent had fulfilled his functions competently.
Lord, I would agree with your lordship if the Federal Tribunal had couched their judgment in terms of saying anything that's relevant, regardless of what type of document it is, or whether it's created internally or otherwise, is to be disclosed if it's relevant to the issues. In which case, what is the purpose of setting out all the types of documents that may be purely internal in the judgment? It's a completely pointless exercise.
No, it's an example of a type of document that would be purely internal.
No.
But my lord, if that were right, and I'm sorry to be arguing with your lordship, but if that were right, things like notes and things like own accounts may well be relevant.
They may be, quite.
And yet, what the tribunal appears to be saying is that those documents, notwithstanding that, are to be excluded. It appears to be what they are saying, where they say they're purely internal documents. The definition is by reference to being purely internal, not by reference to being relevant or irrelevant, is the point I'm making.
Are you going to answer my question, which I now repeat for the third time? What is the distinction between internal and purely internal documents?
The distinction appears to be, and I say appears to be because I'm only looking at what the Federal Tribunal has said, it appears to be documents that have, it talks about the sphere of internal thinking in one of the earlier judgments. So that they're documents that are dealt with wholly internally and appear to be less, or sorry, I should say, more internal than other internal. Because I'm entirely with your lordship as to quite where the boundaries lie beyond the example given.
My internal documents are purely internal. I have no internal documents that are not purely internal, because if they weren't purely internal, they wouldn't be internal.
Well, Lord, the concept of purely internal documents is one created by this judgment.
Well, you say that.
Well, it has created that concept in the sense that it is making a distinction between the two different categories of documents.
But I mean, if the position is that the construction of the Supreme Court's decision makes a distinction between internal and purely internal, which is unintelligible, that may cast some doubt as to whether that is the right interpretation.
Well, Lord, as I say, the words I focused on are the words that were in that 2017 judgment we looked at, where they say exceptions are purely internal documents, no reference to relevance, and the list is the same as the list we just seen.
Well, that may have been a reference to purely internal documents that weren't relevant. No, it doesn't say that.
Well, Lord, I suspect I can't take that point much further forward, but And I think we're probably going to agree to disagree as to quite what the tribunal meant. But
Well, I'm telling you my thoughts so that if there is an answer to them, you can give them. But
yeah, of course, yes, I fully understand. But as I say, I think the answer is see what they've done. And as I say, it can't simply be a question of relevance. Otherwise, there's no point in putting forward a separate category of purely internal documents, which is plainly what they have done. Lord, I don't want to keep repeating myself. I've made my point, and the court will obviously have to take its own views as to what the position is.
okay. Is that it?
Lord, I was just going to say, in relation to where we say the judge went wrong, I can probably do this by reference to our skeleton. If you take our skeleton at paragraph 65 to 76, we explain in more detail why the Chief Justice was wrong. And in particular refer to the 2017 judgment. I think the only other one I need to take is a 2019 judgment.
Yeah.
Which is at tab 8.
Yes.
And paragraph 4.2.2.1.
Sorry, where are we, Mr. Moverley Smith?
So at page 70 of the judgment at tab 8, this is a 2019 judgment.
Right, thank you.
And you'll see there in the last sentence of that first subparagraph, the duty to provide information may also relate to the content of internal documents, provided it's relevant for monitoring the activities of the agent.
Sorry, I don't know where you're reading from.
Sorry, I'm reading, so paragraph 4.2.2.1 at page 70.
Yeah.
And I'm looking at the last sentence of the first paragraph. The two paragraphs, and the last sentence of the first paragraph, which references back to the 139 judgment. And you'll see there's a reference to the duty may also relate to the content of internal documents, provided that it's relevant for monitoring the activities of the agent. And the point made by Professor Pichenet was that there's no reference in that judgment to a category of purely internal documents. But one has to note that this case was about an heir trying to get information about what had happened to some money that had been paid into an account by his mother. You can see that from pages 67 and 68 of the bundle, paragraphs AA and AB. And therefore the question of internal documents or purely internal documents hadn't arisen at all, and therefore wasn't a relevant subject matter for the court to be considering.
Right.
In terms of my Lord's question about what are purely internal documents, the experts have to a certain extent addressed that. And if you take up the bundle 3, at page 182.
Sorry, can you give me the reference again, please?
Yes, so it's tab 8. This is,
Which bundle?
oh, sorry, bundle 3, tab
Yeah.
8.
Thank you.
So this is Dr. Dallafio's
Yeah,
report.
thank you.
And he deals with internal documents and purely internal documents starting at page 182. And then he deals with a question of what are purely internal documents at page 185 onwards. And then at page 187, he deals with what are the characteristics of purely internal documents. For this paragraph, they're rather small numbers, but paragraph 98 onwards. And he continues, I think, to conclude this point at paragraph 100 and 101. So although that's not a definition of purely internal documents, provide some explanation as to what the Swiss courts consider purely internal documents to be.
How would you summarize what he says there, if you can?
Well, he says that the examples are of documents. I'm just trying to find the right paragraph. And he gives examples of purely internal document. Paragraph 99, I think, is perhaps the best way of is the best summary of what he says is purely internal. Where he says a key characteristic of many purely internal documents is that they form part of the agent's internal decision-making or his internal forming of the view, which is quite clearly regarded as a private and protected area and therefore exempt from the agent's duty to account. This inner area of decision-making, forming a view, is distinguished from records of contracts of the principals, which have to be disclosed to the principal.
So if there's an internal document in which the agent records his view, which reveals in paragraph 27 a gross error, that's not accountable. Is that the position?
Sorry, Lord, I've lost where you are.
Assume, okay, I'll start again. Assume that the agent writes a note to himself of his thinking in relation to what he's doing for the principal. It's obvious if you read the note from paragraph 6 thereof that he has made a gross error. That's not accountable to the principal. Is that what you say?
That is a purely internal document under this provision.
And what is an internal document that is disclosable or is to be provided or accountable?
Well, one that doesn't fall within the category identified by Dr. Dallafio.
Well,
So
what does that mean?
Well, he is in paragraph, I think paragraph 99 is probably the best we get. It's the elephant in the room. How do you describe the elephant sort of situation? The Federal Supreme Court defined purely internal documents by reference to a list of examples. That's how they're defined in the paragraph we've looked at.
You see, look at his paragraph 9. Look at his paragraph 98. He refers to as a purely internal document the agent's internal decision-making or his internal forming of a view.
Yes.
Take a doctor who has a patient whose illness is not entirely clear. He writes a note to himself which says, I think it's this particular disease, and therefore there is no need to take any further form of testing.
Yes.
That is, in fact, a grossly negligent view. Upon the footing of paragraph 98,
Yes. That is not.
did you get?
On the footing of paragraph 98, that's not something you would be able to have access to.
Quite. But on the footing of paragraph 100, it is. There's an undisputed core area of internal documents which do fall under Article 400. It's generally accepted that medical records kept by a medical doctor need to be disclosed.
But I suspect the answer would, the question would be, is that note one that can properly be described as part of the agent's internal decision-making or internal forming of a view? I mean, by way of analogy, there may be hugely relevant documents that are subject to legal professional privilege, but may be hugely relevant to whether or not somebody's been negligent, but you don't have access to those documents because of a rule that says those are not documents you can see. In the same way, the court here has said, these are not documents you can see. The position before this case was that all internal documents were not available.
Yes.
So this case has moved on from that and said, now some internal documents are available, but not all of them, because there's still this residual category of purely internal documents that are not subject to a duty to disclosure.
In that regard, you said earlier that there's a list of examples.
Yes.
And I'm missing something. The passage referred to from the judgment gives one example.
It gives...
Such as draft contracts that have never been sent.
There are two passages, my lord. Your lordship's entirely right in relation to the second passage, where we look at the one that's on page 56, the internal page 56, that starts a distinction must therefore be made, that paragraph. Your lordship's entirely right in that paragraph was only a reference to draft contracts that have never been sent. Yeah. But one then has to look back to 4.1.3, where there's a wider category of purely internal documents described. At the top of page, internal page 55. And one also has to look at...
Yes.
Yeah, and one also has to look at the decision in 2017 that we looked at, where the whole list is reproduced in the judgment. Does my lord have that in mind? Paragraph 5.3.1.
Yes, thank you.
Yeah.
Right.
So I think that's all as I say, the more expansive criticisms of the Chief Justice's decision are set out in paragraphs 65 onwards of our submissions. I think I probably made all the points that are made there.
Yeah.
And I just invite the court to read those through if that's possible.
Certainly.
The final point is by way of correction. When we were looking at the order earlier and the paragraphs that were impacted by waiver, I think I overlooked the fact that paragraph 3 of the order is also relevant to the question of waiver, because if you look at paragraph 3 of the order, there's an obligation to provide copies of all letters of request and responses received from the bank. So there was no reference to waiver there. It's clear that that obligation, which is in addition to the obligation of providing the affidavit, would involve a waiver of the privilege that we've been discussing.
Yes.
Thank you very much for your time.
Thank you very much for your submissions. Right.
Mr. Hollander, I think it's your turn. Yeah, I can't hear you. Can anybody else hear Mr. Hollander?
I can't.
Ah.
Still not hear me?
Yes, you can now.
Hear you now? Oh, yes.
Good. The substantive points in Milan and Friends submissions are: one, the jurisdiction point under 24 Rule 7 and the overriding objective; two, the waiver of privilege point; and three, the Swiss law point. Now, I was going to start. I was going to start my submissions by just taking the court to the circumstances in which the Chief Justice made the order, the complete failure, we say, of the of CS Life to give proper discovery, and the volte-face just before the hearing, when they completely changed tack as to the position as to what was accessible. I'm just not entirely sure, on the basis of Malone and Friends submissions, whether any of that matters anymore. He did faintly make a submission that the Chief Justice ought not to have made an order at all. But I'm not clear at the moment as to whether anything other than those points, the first one of which being a jurisdictional point, are still an issue. So I think it's a matter really for the court as to whether they want to hear me on that first matter, as to really the circumstances in which this came before the Chief Justice and why he was plainly justified, subject to the 3 points I've mentioned, in making the order that he did.
Well, the way in which I recall Mr. Moverley Smith dealt with it was to refer to certain, to say, broadly speaking, that the even if he had jurisdiction, the Chief Justice ought not to have made the order, and to refer to certain paragraphs in his submissions, which I've noted down somewhere, but don't have in the forefront of my mind.
Yes. Well, it sounds as though I do need to deal with the point. Yes.
Briefly.
So CS Life's position until just before the application to the Chief Justice was we have very few documents, all of which are contained in our first list. Otherwise, we are dependent on asking the bank and them giving us documents. And there were a series of further lists drip-fed to us, all said to have been documents which the bank provided to CS Life. Now, that was coupled with them saying the right to demand documents to the bank was a very narrow right under their interpretation of Article 400. If you go to paragraph 18 of my skeleton, which is really where I pick this point up, page 6, please. So, Ms. Roche, in her witness statement, referred to in paragraph 18, essentially says, but actually, if you look at the documents that have been disclosed, you can see that the CS Life people who are receiving and sending emails have a dual role because they appear to be bank employees, bank email addresses, single server, and they seem to be have a single document management system. How can that be the case? We then have, on the eve of the hearing before the Chief Justice, Coffee 4, which completely changes the position, and Coffee 4, which is referred to in paragraph 20 of my skeleton, essentially accepts that the CS Life, the dual function, and says that almost all the employees of CS Life were actually bank employees who were employed with a dual function. Many of them were appointed as officers of CS Life in order that they could sign contracts and the like on behalf of CS Life, and accepted that there were significant categories of documents to which CS Life had access. And in the light of that, the judge, not surprisingly, concluded, and it wasn't objected to by my learned friend really at all, that CS Life were entitled to access to a whole range of documents which had been completely contrary to everything that Mr. Coffey, who was an ex-employee of 3 years before, had said in his previous affidavits. And so that was where it arose. And we set out in paragraph 20 the categories where Mr. Coffey accepted, but and then point out in 22 that actually, but he didn't give any detailed information about what searches had been done and the like, or whether the documents to which he now accepted, contrary to what had previously been said, CS Life did have access, had actually been searched, and if so, by whom? And in particular, whether by the bank or by CS Life. And there's given that in respect of redactions, it was apparent from Miss Roche's evidence that what had happened was that CS Life had received a whole number of original unredacted documents from the bank at the time. It was apparent that the redactions, which in many cases were shown to be inappropriate, had been done not by CS Life or their lawyers, but by the bank, which is what Mr. Coffey was saying. So it then became apparent that actually the discovery had not been done by CS Life at all, that they had taken a view as to which documents they had, which was now disavowed in Coffey 4, and that essentially it had been done by the bank. And the point we make, for example, at paragraph 22F, is that the only documents which were said to be the documents of CS Life as opposed to the bank, other than a bunch of contracts, there were 11 email chains which were disclosed in their first list and said to be CS Life's documents, but these appear to have been given to them by the CS Life compliance officer, according to Coffey, for the purpose of doing the defense, leading to the inference that CS Life provide documents as and when it suits them. Now, that was the background against which the Chief Justice was asked. 22G, we point out that Mr. Coffey appears to be claiming privilege in some very doubtful circumstances without, again, giving a chance to be able to test that or actually any details which would enable us to test. This was documents that on the face of it didn't look as though they could all possibly be privileged, but he was saying they were privileged, and it was said that we couldn't test that. So it was with that background that the Chief Justice, with this about turn by Mr. Coffey and CS Life on the eve of the hearing, in circumstances where we had been complaining all along about the nature and extent of CS Life's discovery, and how effectively it was being run entirely inappropriately by the bank. Once one's seen Coffey 4, it effectively showed that everything that the plaintiffs had been complaining about the discovery was in fact true in spades. So that was the background against which, I said I'd do it briefly, against which, and we've set it out in quite a lot of detail in the skeleton, and I won't repeat it, but that was the background against which we were complaining about the discovery. And indeed, you've seen from the draft order, which was proposed by my learned friend, Mr. Moverley Smith, in the course of the hearing, that they were conceding a certain amount, at least, in the light of that. So that was the circumstances in which the Chief Justice was very much entitled to make the order he did, subject to these 3 points. So I'm now going to move, if I may, to, having dealt with that fairly rapidly, to the question of jurisdiction. And as I understand my learned friend's submissions, he really puts it 2 ways. There's the broad and the narrow approach. There's the broad approach, which he adopted before the Chief Justice, which is that 24/7 has a specific wording and there's no power to do anything else. And that, in other words, it doesn't matter what the inherent jurisdiction and the overriding objective does not give the court a power to do what the express wording of 24/7 doesn't enable. That's the broad submission. The narrower submission, which he made before the court today, was that because not the summons, but the affidavit in support referred to Order 24, Rule 7, that was the only order that one was entitled to consider. And I think he put it before your lordship, before the court, both ways. So if we can just deal with those submissions first.
Mr. Hollander, just before you go there, what I'm not understanding, and maybe this is the question for Mr. Moverley Smith, not for you. What I'm not understanding is, given the background and what you say was the volte-face at the last moment, why is there now an objection to every paragraph of the order effectively?
Well, we were somewhat surprised by that because as you know, my learned friend actually proposed his own rival draft order. In the light of the first day and the way we had originally said in advance, look, it's not, we think these documents are documents of CS Life, not the bank. Once we had actually got Coffee 4 on the eve of the hearing and actually had been in court before the Chief Justice on the first day, we thought actually it would be sensible to provide a new draft order which reflected the distinction between what was obviously the CS Life documents or documents in their control and those that one couldn't properly say were in the control of them because they were in the control of the bank. And that's why we tried to produce a draft order. The learned friend then produced his rival draft order as to what he was prepared to offer by way of discovery, and invited the Chief Justice to make that order. And as you know, the Chief Justice went, except for one minor point, which doesn't matter, in favor of what we were seeking. So he was actually proposing that the court make an order very significantly greater. I mean, he now appears to be saying that the Chief Justice shouldn't have made any order at all, as I understand.
Well, that's what I was asking you, and I don't quite understand why there has been a complete volte-face as opposed to a limited one.
It's not the first time, as your ladyship knows. And in fact, the Chief Justice himself remarked on that, I think, in the ruling on leave to appeal, which you have at bundle 1, you probably see, you perhaps didn't even turn it up, it's bundle 1, page 33, paragraphs 5 to 7, where he makes exactly the point your ladyship's making to me now about the volte-face. But it's not, I mean, our position has been, the bank has been running this disclosure, not CS Life. CS Life has not fulfilled in any respect its obligations, and it really should do so now. I mean, that's been our position all along, and the ducking and weaving, as it were. If the position now is taken that no order at all should be made, and as your ladyship puts, is a volte-face, that does not come as a great surprise to us. So the starting point, I think, is that as the court has seen, the summons is entirely general in terms of the basis for the order. It does not refer to Order 24, Rule 7 at all. It is, on the contrary, it simply asks for the orders sought. This is bundle 1, tab 10. And it actually, for what it's worth, in addition to that, paragraph 2, it produces the catch-all. So this is bundle 1, tab 10. Further and/or other directions and/or relief as the court may deem appropriate. So actually, there's a bit of a catch-all there for what it's worth. But there's no reference to, there's no limitation to 24/7 in the summons. So the argument before the Chief Justice was that the only relevant power was Order 24, Rule 7, and that one can't, my own friend was saying, you can't use the overriding objective or inherent jurisdiction to rewrite the specific rules. Now, the judge, the Chief Justice, as the court knows, decided this with reference to the overriding objective. And we can see that from paragraphs 53 and 54 of his judgment, where he specifically finds the court does have power. This is tab 1, page 13 of the first bundle. He specifically finds that the court has power to make these orders pursuant to the overriding objective. So now, I made my submissions with reference to the overriding objective at the time. You needn't pick them up but in the transcript bundle at page 383, you will find the reference to where I made the submission expressly with reference to the overriding objective. And as I said, no need to turn that up. It's page 383 of the transcript bundle. So that was what was an issue before the Chief Justice, and I don't remember it being suggested that there was some technical point about the summons or the affidavit to suggest that that wasn't something open to me. Indeed, if it had been, I would no doubt have, if that had been something that had arisen, asked to amend the summons or whatever. So that was the basis of the argument before the Chief Justice, and as our skeleton before the Chief Justice referred to the overriding objective, and the learned friend, I think now, as I said, puts it on both the narrow and the wide basis. And as my Lord the President put to him in argument, well, if this technical point were to have any merit, which I'd submit it plainly doesn't, then we just go straight back to the Chief Justice and ask for the orders now under the overriding objective, which he's made already. See paragraph 53 and 54, and I'm not quite sure how that process would further any overriding objective. I think my learned friend's other point is that actually there's a wider submission, which is that it doesn't matter whether you've got an overriding objective or whether you've got inherent jurisdiction, it can't cure the problem. And I think that's his broader submission. And I think one can understand the submission. He's referred to a lot of cases about statutory interpretation, but I'm not sure, with great respect, that helps very much. One's looking at the jurisdiction of the court to make orders to ensure its own orders are effective, which is what the Chief Justice was doing. Now, what we've done in the skeleton, we've done a little tour, as the court will probably have seen, of worldwide authorities. We've looked at quite a number of jurisdictions. We haven't included all of them, but we've included the ones we thought were most helpful. I'm going to take them at a bit of a canter because they're only examples, and you may think that some are better examples than others. I would suggest that actually the central point is the point made by Lord Dyson in Al-Rawi, which is, let me find that for you, which the learned friend took you to briefly. I would suggest that actually sets out what the court is able to do. And if you look at tab 33 of Authorities 2, it's that paragraph 20. We looked at it earlier with the learned friend submissions. And there is Lord Dyson. So it's page 574 of the report in tab 33, paragraph 20. Where Lord Dyson is looking at the power, the inherent power of the court to introduce procedural innovations in the interests of justice. And the first two examples he gives are really quite interesting. They are Morava injunctions and Anton Pillars. Both of them done under the inherent jurisdiction. And then he goes on to say, of course, it's not an unlimited power because you can't, there are some things which are effectively, he summarizes the principle at the end of paragraph 22 at C on 575. The basic rule is that the court cannot exercise its power to regulate its own procedures in such a way as will deny parties their fundamental common law right to participate in the proceedings in accordance with the common law principles of natural justice and open justice. So that's the limitation of the principle, but otherwise the power of the court is to make its proceedings effective. And that in our submission, in what the authorities generally suggest is that it used to be done under the inherent jurisdiction, and generally, since the courts have developed overriding objectives and incorporated the overriding objectives into their rules, the convenient and normal way to do it is pursuant to the overriding objective, rather than talk about inherent jurisdiction, but it really doesn't matter very much which. So that's what we say the principle is. And in the skeleton, we refer to a whole range of different jurisdictions. In paragraph 42, we looked at the BVI, which is the Eastern Caribbean Supreme Court. And we looked at that decision. I perhaps needn't go back to it. It's relevant because it is on methodology specifically and searches. So it's factually on point. And there are the passages that we've referred to. We've referred to them in some detail in the skeleton, where the court is talking about the court's power pursuant to it. The BVI uses the CPR as modified with an overriding objective. Many of these jurisdictions prefer to use the RSC or based on the RSC. So the Catherine Maywai Fong case is one where the Eastern Caribbean Court is using this power to do exactly what the court was asked to do here. And we set out in paragraph 43 the actual order the court was made. So that's the British Virgin Islands. Now, at 46, after referring to Al Rawi, I draw attention to another, an English line of cases where the courts have used the inherent jurisdiction or overriding objective to make orders supervising one party's discovery when they can't do themselves. And again, these are only examples. The Muller Europe Group is a decision of Mr. Justice Coulson, as he then was, where he said, look, searches need to be done by the defendant, but it's perfectly obvious he is not technically capable of doing these electronic searches. So I will require them to be done through an expert appointed. So the court is actually procuring the appointment of an expert effectively to supervise the defendant's disclosure. The Nolan case, which is Mr. Justice Tier also referred to in that paragraph, is another one where rather than take judgment in default, the claimants wanted an order for disclosure first. And it was done with a supervising solicitor because the defendants couldn't be trusted to do it themselves. So the court is appointing a supervising solicitor to give the defendants discovery. There's a whole bunch of English cases on those. They're all slightly different. I've referred to in a footnote good old documentary evidence. I should just say the reason I've done that, I don't cite my own book in court, but it just summarizes about 7 or 8 cases. I don't.
You're still alive, Mr. Hollander.
Well, I'm still alive, and it's good to show that. But also, there's a judgment of Sir Richard Scott where he said counsel was able to provide no authority for this surprising proposition, save for a sentence in his own book. And I thought, I never want that to be said about me. They're just there as a compilation and nothing more than that. But I've given you the reference. So that's England. There's also a quite useful reference, and again, we needn't spend time on it, in the White Book. The better one is 9A68, which is A113. Again, I'll just give you the reference without spending time on it. What it's doing, it's quite a nice just summary as to inherent jurisdiction and the breadth of the inherent jurisdiction. It's about 2 pages in the White Book. And essentially, it's looking at the breadth of the inherent jurisdiction of the court to be able to do to make orders, to make its own orders effective. The next area we looked at was TAR, predictive coding. Has the court got power? It's a different type of example. Has the court, this is paragraphs 48 and 49. Has the court got power to make an order which permits predictive coding, technology-assisted review, TAR, by way of doing disclosure? There's an Irish case called Quinn, which is referred to in paragraph 48, where the court endorsed this as part of the party's discovery exercise, despite the fact there's nothing in the rules about it. That is a slightly better example than Master Matthews in 49, who's the author of Matthews and Malek, where he does the same thing in an English case called Pirro. The reason that 48 is a slightly better example is because the principle was disputed in 48, whereas in Pirro, neither party specifically objected to it, so long as the court thought it has power. So that's 48 and 49, again, a different type of example. 50 is Hong Kong, Hong Kong uses the RSC and doesn't like the expression overriding objective, calls it the underlying objective. But there was a practice direction on e-discovery, and the judge in Chinacast gave effect to it even before it had come into effect, pursuant to the underlying objective. Now, these are all examples, but every jurisdiction has power, in my submission, whether you call it inherent jurisdiction or overriding objective, to be able to make orders, to make its own orders effective, which is exactly what the Chief Justice was doing. We've set out in paragraph 51 of the skeleton why, as a matter of why it is appropriate in our submission that Bermuda should do precisely that. But we couldn't find, there's a whole bunch of jurisdictions we looked at for the purpose of this submission to show the court some examples where they weren't quite such good examples for all sorts of different reasons, and therefore we didn't want to overburden the skeleton. But there isn't one where the court says, no, you can't do it. You've only got the wording of something like 24/7 and that's all you can do. Of course the court can do it. How otherwise can the court make its orders effective? Anyway, so that is really the submission we make in respect of that. And 51 is the policy reasons we put forward as to why we would submit that the court has this power. And one looks at the learned friend's skeleton. The complaint is this is being done by the bank and at the bank's behest. And we see paragraph 40 of his skeleton. And I think it is worth, if the court doesn't mind, just turning up page 11 of his skeleton. So we all know that discovery is a non-delegable exercise, a matter of importance to be done under proper supervision by the lawyers. And what does he say in paragraph 40? In paragraph 40 brackets 1, CS Life had searched its own documents via the bank as its agent. So what he's saying in terms is that actually the bank has done this, not us. And in our submission, that is key point which is being made. We've also got Singapore as well, I think, in paragraph 55 referred to for what that's worth. And we again emphasize the point in paragraphs 57 and 58. The solicitor has a non-delegable obligation. That's what Myers and Ellman was all about, to supervise the disclosure. The client has an obligation. You can't just get some third party to do it, particularly if the third party is somewhat partisan in respect of this. And that effectively is the problem that the Chief Justice was addressing. So I think that, subject to any questions the court has in respect of that, was what I wanted to say by way of the jurisdiction point.
Mr. Hollander, could I ask you, as a matter of practicality, what documents you're actually after here that you haven't got, or you think you haven't got?
Well, we've had virtually no transparency about what went wrong in the relationship. We were told by the bank that they would show us I think there was an accountant's report into the collapse. We've had nothing from them. We know that the account manager is in prison for fraud. And we know, and we've had very little, we've not really had any visibility or transparency as to what happened. And what we're trying to do is to get as much information as we possibly can to see actually why this happened and what the involvement of the bank was and what the involvement of CS Life was.
And is the accountant's report covered by some sort of Swiss obligation of confidentiality, or why haven't you had that?
Well, we were originally promised it by the bank, I think before litigation started. The bank have declined to. I think on analysis, I think it's a PwC report. I think we were told that it was a document of the bank, and I think on the evidence as it stands at the moment, it looks as though that is correct.
Yeah.
It seems to us it must fall within Article 400, where as the Chief Justice has held, this is all about the documents and materials which enable the principal, which in this case is CS Life, to determine whether his agent has performed his mandate. And you would have thought a report by PwC or the like into the reasons for the collapse and the loss of value would be precisely what would fall within that, because it's of fundamental importance. But we haven't had it so far. Whether we get it from the bank, we'll see. But it must fall. I mean, it must fall within Article 400. The duty. If the principle is that the agent has to produce all materials and documents to enable if the agent has to produce the materials to enable the principal to decide whether the agent has performed his mandate, you would have thought that was about the most important of the lot.
Yeah.
So I was going, unless the court has anything further on that, to move on to waiver of privilege.
Yeah.
Now, so can I just deal with the materials first? So we looked, I think, in the Learned Friends submissions at bundle 4, the Appleby letter of 2nd of July, which is page 464, red 261. And the reason this is relevant is not because it was a letter, but because it's incorporated by reference in Mr. Coffey's witness statement. And that's why this matters. So when one looks at on page 465 or 262 at the categories of documents, what they are doing, what Appleby's are doing, is in the light of Hurrion for my clients saying, but you haven't produced the document and you haven't, have you asked the bank? They go through in respect of each category which is sought. They say they've made requests and they explain what the requests that they have made are, and they say, and then, so it's a standard format for more or less each category. There's the paragraph we see under categories of documents. Do you see CS Life has made requests? Middle of 465. Oh. Yeah. To the bank for documents in these categories previously, and then it specifies. And then in the next paragraph, after the fact that, after the first sentence, in an attempt to allay those concerns and consistent with the overriding objective, yes, we on behalf of CS Life have made a further request for documents. The request seeks any documents falling within classes of documents and specific documents mentioned by the plaintiffs in the June 2009 letter under this heading. And that rubric is followed in pretty well every category. And it's basically a word process, scissors and paste. We needn't go through the other categories, but it does in between that page and page 470, in respect of more or less all the categories which are sought, it uses precisely the same rubric. So that's the starting point. We then go to copy 3, paragraph 27, bundle 3. And so we see in paragraph 27 that what Mr. Coffey is doing in paragraph 27 on page 41 of tab 3, he is saying that as set out in the letter of 2 July, so he's incorporating by reference the letter, whilst the defendant doesn't accept its discovery as deficient, it made a further request for the classes of documents and specific documents identified in the Hurrion letter. So it's telling the court what it's done in terms of the request of the bank. The documents identified in the Hurrion letter substantially mirror the documents sought by the plaintiffs in this discovery application and the further bank request requested the specific documents and categories set out in that letter. And then in 29, the bank responded to the further bank request on 23rd of September and provided further documentation which includes and then sets it out. So that is the material on which the waiver is based. So the next question is what the law is. Now, this is an area where the authorities have always been a bit confusing. The early cases that my learned friend referred to, Marabini, Tate and Lyle, there's also a Derby and Weldon case as well, which isn't in the bundle, doesn't matter. They are very difficult to reconcile, and that has been recognized in more recent authorities. There are two modern cases which set out the principle, and both of which you've been shown. One is Brennan, Mr. Justice Elias in the Employment Appeal Tribunal, and the other is the Court of Appeal in Joe Bloggs. And they both say the same thing. And the relevant passage is set out by the judge at paragraph 61 of his judgment. So if we can just pick it up there, please, which is in bundle 1, tab 1. It's just quite conveniently set out in paragraph 61. So what the court has been doing, so this is page 15 of the first tab of bundle 1. What the court has been doing is it draws a distinction which is slightly, makes one blink slightly, between reference to the effect of the document and reliance on the content. What does that mean? Well, it all comes from, the starting point is Mr. Justice Mustill in Nea Carteria. And here's the principle, which is again set out in paragraph 61 of the judgment from Nea Carteria, is deploying in court privileged material. And it's the cherry picking principle. You can't take a voluntary decision to put in your own interest privileged material before the court without making available, at least to your opponent, all the material relevant to that issue. That's the starting point. And then the court talks about deploying in court. It's all about deploying. And there seems to be a distinction drawn for this purpose between reference to the effect and reliance on the content. I think the way of looking at it is like this. If one said, when we received Hurrion's letter, we sent a letter to the bank. That would, I think, probably be a reference to the effect of the document. But if one says, when we received the Hurrion letter, we sent a letter to the bank asking them for the documents referred to in the letter, then you're relying on the contents of the letter. Are they relying on the contents of the letter? Well, the reason that it's apparent that they are is because the whole point about this passage in Mr. Coffey and the letter which he incorporates is that what they are doing is trying to deflect criticism or possible criticism by saying, look, we've done what we could. You asked us for these documents. This is what we asked the bank for. In other words, they're trying to show they've done what they say they were obliged to do by by incorporating, as it were, the contents of the Hurrion request in and saying, this is exactly what we did. So they are relying upon the effect, they are relying on the contents of the letter. They must be. And
it's a very, very odd position. Solicitor writes to the solicitor on the other side, your disclosure is defective. There are whole categories of documents you haven't disclosed. We set them out.
Mm.
The solicitor to whom the letter is written writes to his clients or writes to a third party and asks for those documents. If he replies saying, we sent a letter, that is not waiving any privilege. If they reply saying, we sent a letter asking for the documents that you asked us to ask for, that does.
Well, I agree with my lord that it is slightly curious. Which is probably why some of the old cases are very difficult to reconcile with each other, because they seem to depend on slightly minute distinctions. And I think everybody has always said that the 1980s cases are very difficult to work out. Now, I completely agree with what my lord says. However, that appears to be the principle, and that's been set out by the English Court of Appeal and Miss Justice Elias as well. And I think that if one goes back to the cherry-picking principle, to the relying on document, what they're trying to do here is rely upon the fact that what they have said to the bank in order to deflect criticism, and yet not produce it. And it's that inconsistency, which is the cherry picking, which I submit must be a waiver of privilege. But I completely accept that it's a slightly curious distinction. I think one's got to go back to neo carteria. It's deploying in court. That's where it all comes from. And I think so. The learned friend, and of course, exactly what's encompassed within that. So let us suppose that they're obliged to produce the letter to the bank. And then let us also hypothesize that the next day they write to the bank saying, we have, the letter of yesterday was written because for cosmetic purposes, in case we had to show it to the court. Please ignore everything in it. So, I mean, just hypothesize that. The second letter would fall within the waiver. That's part of the cherry picking. So that I think it's important with respect that is included as well. So that's why the Chief Justice. So there are two bits in the order which are relevant to this. There's the second recital, as the court has seen, where it's the first recital. Sorry, the first recital that privilege has been waived in relation to CS Life's requests and and referred to the 2nd of July and the third affidavit and the responses received from the bank. And then that is picked up in paragraph 6, where there is an order for disclosure of the documents between the documents which fall within that. So I think that's the scheme of the order. And the court asked, I think the court raised the question earlier when Learned Friend was making his submissions. Well, are these documents privileged at all? I think it's possibly debatable. We conceded at the time that they probably were privileged, because I think if you ask what effectively is a third party for documents pursuant to your disclosure obligations, they probably are subject to litigation privilege, although one could debate that. But I accepted that before the judge. But in our submission, once you've actually gone to tell the court and relied upon what you've asked the bank for the very purpose of deflecting criticism and seeking to show that you've done a proper job, well, you can't have it both ways. So that's my submission on waiver of privilege. And I think that leaves Swiss law, unless there's anything the court wanted to raise with me at this stage.
I don't think so.
So on Swiss law, and I think the court has made many points.
Sorry, I thought you say that if you write saying we wrote to the bank asking them to produce the documents you asked for, that is a waiver of privilege in relation to the letter of communication and the response from the bank, but it's also a waiver of privilege in relation to what? All previous and all subsequent requests for disclosure?
Well, I'm not sure I'd need to go as far as that. I mean, I thought the wording of the Chief Justice's order really encapsulated it. There's a waiver of privilege in respect of the requests and the responses. And I think, so just take my hypothetical example of the ignore our letter of yesterday. I think that would fall within the first recital and paragraph 6.
Well, wait a minute. Yes, it would, but what about the requests that were made before July 2019? It said that all communications between CS Life and the bank from the commencement of this litigation onwards, asking for disclosure, together with the bank's responses, all privilege has been waived in relation to that.
I don't think we went as far as that, which is why the first recital is linked to the 2nd of July letter and Coffee 3. Coffee 3 was dealing with, if one just goes back to it at page 41, Coffee 3 was dealing with the requests made in the light of the Appleby letter of 2nd of July. As referred to in the Appleby letter of 2nd of July, the further requests which were made, and I think it's tied in also to 27 and 29 of Coffee 3. So I don't think it's quite as wide as my lord's putting to me.
Well, I'm sorry, I'm now lost.
Sorry.
Are you accepting that if there has been a waiver of privilege, it is in relation to the requests that were made to the bank for the documents in Hurrion's letter of the 19th of June and the response, and the request to the bank and the bank's response in relation to the documentation referred to in the 23rd of September.
Yeah, I think that is what that's how I understand the order.
The 2 letters.
Well, it may not be 2 letters. We don't know.
So wait a moment. It's important to be clear about this.
Yeah, understand.
You say the waiver is in respect, is this right, of the request referred to in paragraph 27 of Coffee 3?
Yes.
And the response thereto?
I suppose that I'd say anything ancillary to that. In other words, that gets my ignore yesterday's letter. But I'm not saying it goes. It is a wholesale waiver, and I think that's what the order. So if you look at the order, so the waiver is the requests referred to in the 2nd of July, which are saying we've just asked the bank again in relation to this, which is I think what Coffee 327 is saying, and the responses. So in response to Hurrion's letter, Appleby say, we have asked the bank for this. It may be 1 letter, it may be more, and the bank's response, which may be 1 letter and maybe more.
So, okay, it's the request to the bank for what was contained in the Hurrion letter and any response thereto.
Or responses, yes.
Or response, yeah, yeah.
Yeah, I think that's the effect of it.
Right. Okay.
Yes. I'm being passed a message that it may go slightly further from that. I mean, it's the request. So, I mean, if we just look at the order, it's the request to produce documents referred to in Appleby, to the categories in Appleby's letter. Please go back for a moment to the Appleby letter. Sorry, I don't want to get this wrong. The Appleby letter is saying, so if you look at page 465, CS Life has made requests for documents in these categories, and we're doing it again. So I think, sorry, I'm perhaps slightly wrong. It's covering both. It's the documents in the categories are referred to, but both prior and subsequent.
Wait a minute.
Yeah, sorry, my fault. So so if you look at 465 on bundle 4 tab 2, which is the Appleby letter. So what they're saying is CS Life has made requests and has done it again.
By these categories, Mr. Hollander, you're referring to the heading there, all documents, evidence, all documents.
I'm so sorry.
Yes.
Yes, but if you follow the letter through, I only took the court to that one, but if you follow the letter through, the same rubric is applied. So if we go 2 pages further, and if you look at documents in relation to audits and risk assessments, for example, on page 467, you see exactly the same wording. CS Life has made requests for documents in these categories previously, and then next paragraph, we've made further request. And so the same wording is used for different categories.
So it is, you say the waiver extends to requests made for the documents referred to, referred to in the Hurrion letter.
Yes.
Well, at any stage, effectively.
Well, within those categories, because that is incorporated in Coffee 3 at 27 and 27, where he effectively incorporates what's said in the letter in his paragraph 27 in relation to those categories, both prior requests and subsequent requests.
Sorry, prior to what?
Well, sorry, he is adopting the 465 wording where CS Life has made requests in these categories and is making a request again in this category. So there are two. One is the requests that have been made in relation to the category, and 2 is the requests that is now being made, or the repetition, if you like, in that category. And that wording is used in more or less all these categories.
Well, yes. Well, what it says in relation to this is, take page 465, the first category. CS Life has made requests to the bank.
Yep.
And then in the next paragraph, it's made further requests to the bank.
Yes. So what Coffee is doing is relying on the fact that 1, we CS Life have made a prior request, and 2, we CS Life are making a repetition or a further request.
So it's not our making. It's not our making. It's have made. It says we asked
yes,
once and
right.
asked a second time.
Quite right. Thank you.
So the waiver is to the requests made, both originally and second time round. Is that right?
Yes, that's right.
Right.
Mr. Hollander, could I just be clear? Are you actually asking for the documents as well as the requests?
No, the waiver covers the requests.
Not
the request and the response.
Yeah, but not the documents referred to in the.
No, that was never suggested.
Yeah,
It's-
I thought that was
it's-
the position.
yeah.
I just wanted to check as a result of something
Sorry,
you said to
it's-
my lord. Yeah.
It's the requests. It's the requests, former or subsequent, and the responses.
No, not subsequent.
Oh,
Form
no, sorry, no, sorry. You're right. You're right. I'm so sorry.
Don't
Yep, I'm confusing you.
confuse me. Yes,
No,
you are.
I'm sorry. You're absolutely right. I think my lord's got the point.
I have now, yes.
Well, I apologise. I wasn't as clear as I might have been. Shall I move on to Swiss law, unless there's anything further you want to hear me on?
No,
Yep.
Speaking of myself,
Yes, thank you.
Thank you. So, Article 400, 2 duties, 1 to surrender, not relevant here, and 1 to account. And until 2012, the Swiss Federal Court, the Swiss top court, regarded those two as coextensive. The 2012 decision was revolutionary in the sense that it gave meaning to the duty of account, which went beyond the duty of surrender. And everybody agrees so far. The principle, which is set out in the 2012 decision, is the agent has to hand over documents which are relevant to enable him to enable the principal to see whether the agent has fulfilled his mandate. That is the principle. Now, so what Professor Pichenas, who is professor of law, he's a professor at Freiburg University, he's a rather distinguished academic, says, well, that excludes irrelevant documents. So if, for example, you write an internal note to yourself saying, I must call X tomorrow, well, that's not relevant in the normal course to anything. And therefore, unless there's some exceptional reason why it should be relevant, that falls within what is rather perhaps infelicitously referred to as purely internal documents. Draft contracts was another example where they have never been sent to the other side. So the examples they're giving are documents which in any normal circumstance are irrelevant. Professor Pichenas said, and was absolutely clear throughout his evidence, that's the principle, that's what the court was saying in 2012. And if you look at the 2019 decision, that shows that they're just talking about relevance. So that was his evidence. Dr. de la Fiore, who's a commercial litigator, said that there were two categories of internal documents. There were internal documents that were disclosable and purely internal documents which were not disclosable. And he's picked on that wording in the 2012 decision and said you have to draw a distinction between the two. So that was the issue. The Chief Justice has heard the evidence. It's not a case where the court is simply construing words. It is interpreting in the light of expert evidence under cross-examination of Swiss law, the Swiss law concept, which was on which he was assisted by the evidence of the experts. And he has made it clear, and perhaps not surprisingly in the circumstances, that he preferred the evidence of Professor Pichenas. Now, I just want to show you, because it was,
Mr. Hollander, are you submitting that the judge had the ability to judge or determine the intellectual ability or ability to rationalize or to argue or analyze the relevant cases, and preferred the approach, the analysis, the intellectual skills of one expert, your expert, rather than the other?
Absolutely.
Yeah.
So, I mean, it's not, sorry.
Nothing new in that. And you say the judge formed an evaluative judgment of the intellectual skills, rigor, ability to analyze, strength as a lawyer, and preferred yours to the other.
I mean, you know, the judge heard it. I mean, we were there. I know this court, we were there. Professor Pichenas, who's a very distinguished academic, was absolutely clear and never wavered 1 inch. And I'm going to show you in a moment that it was almost impossible to work out what Dr. de la Fiore actually was saying about this. And some of the points that I'm going to make were actually already made in argument to my learned friend. But
how long did it take, the expert evidence?
The Chief Justice said he wanted it limited to an hour and a half each side. can I just show you 4 or 5 passages quite quickly from the transcript? If you've got the transcript of my cross-examination of Dr. Delafio. So,
No, can you give me the reference?
Yeah, if you've got, it starts at page 271 of the transcripts bundle.
No, I need something better than that, please.
Oh.
Because I'm working electronically, which is...
Bundles 1 and 2, tab 19.
Thank you very much.
Bundles 1 and 2. I'm sorry,
Yes.
but I have to go back into the documents each time.
Tab 19.
I don't know if Miss Hurrion can help on that.
Bundle 1, tab 19.
Bundle 1, tab 19. Thank you.
Starts at page 225.
Thank you very much. Don't wait for me. I'll get back in there.
And my cross-examination of Dr. Delafio starts at 271. Does my ladyship have it?
Yes, thank you.
Right. If we turn to 273, so I ask at line, do you have line 12 all right?
Yes, thank you.
So one employee writes an email to another internally in relation to a mandate contract, says, we made a complete mess of our mandate. We sold when we should have bought. We used the wrong benchmark. Taking that example, enormously important in determining whether the agent's in breach of duty. Is your evidence the Swiss court would take the view there was no need to provide this document to the principal under the duty of account? Answer, no duty to provide it. And I was told, and I've had this in court, and I was told I wouldn't get the smoking gun. So that's his evidence. Then we get to 276. And I put to him line 11 is essentially that's inconsistent with the principle. I'm trying to establish is whether you accept that sentence is an incorrect summary of the principle. You say there will be what may be absolutely vital documents relating to the transaction carried out and whether the agent has fulfilled the mandate, which don't have to be disclosed. Would you suggest that inaccurately sets out the principle? I don't accept that. You have to read that with the exception. Exceptions are purely internal documents. So and then I say, well, how can that duty of account be fulfilled? So what he's saying is that the principle is subject to this exception on purely internal documents. Now, we then go to 286, where the Chief Justice asks him, and the details of the 2012 decision are being put to Dr. Delafio by me. And then at line 16, the Chief Justice says to Dr. Delafio, internal documents can be produced provided they're relevant. So he's actually suggesting that the decision is actually saying that. Dr. Delafio, they were necessary. I don't think the relevance would open an entire feed. Here, it was inevitable to have these documents, to have this calculation reviewed. This is the opening of the case, which we as practitioners welcome. It's not more than that. So the Chief Justice's question was correct, wasn't it? No, it doesn't say relevant. So what he seems now to be saying is the test is necessity rather than relevance, which we haven't heard from him before. And then I ask him about the principle. And if you look at line 30, this is a question my Lord the President asked the learned friend several times as to what the principle on purely internal documents. Line 13, it's exactly, they did not state a principle on which they decided that. They decided this on a case-by-case basis, as I say. Here they thought, well, they need to have this information. So on the one hand, Dr. Delafio is saying there isn't a principle here as to what is a purely internal document. It's case by case, whatever that means. But he's saying in a case where, and I think this picks up his necessity point on the previous page, where they need to have the information, they can get it. So it seems to be he's moving away from his position that there's an exception to the principle on purely internal documents, to be saying that if they are necessary, whatever that means, that you can have them. Then 288, line 14, again, he's at line 14, he's saying, I'm trying to take this as quickly as I can. He's saying, line 14, they expressly say whether it's necessary, not relevance. They say whether it's necessary. So he seems now to be accepting, contrary to what he said previously, that if you have a document which is necessary to be produced, then it has to be produced. So I say, are you saying all information which is necessary must be disclosed, whether internal or not? Or what are you saying about that? Answer, I'm not saying anything. I'm saying what the Supreme Court says, and they say when it's necessary, even if it's internal, it has to be disclosed. If it's necessary to verify the exercise, to verify the management activities of the agent, and then he goes back to his starting point, provided it's not a purely internal document. So having, I thought, got him to say that the test was necessity, he's now saying, A, it's necessity, and secondly, provided it's not a purely internal document. And then the Chief Justice tries, bottom of page 289, so having line 23, where the witness is saying, I think the standard is necessity, Chief Justice, so are you saying if the document is necessary, even if it's a purely internal document? And then he says, no, if it's internal, the sentence I read, in the distinction of the internal documents, the purely internal documents are out. There is and always was an assumption that purely internal documents are in any way irrelevant because they've got nothing to do with the mandate as such. For example, internal investigations, audits and things. Question, this is I think still the Chief Justice. So in relation to internal documents, providing you say they are necessary, they have to be produced. So he's trying again, the same point. Answer, they have to be. The content of the documents has to be brought to the attention, yes. So at this stage, he seems to accept that if they are necessary, then they have to be disclosed. And then at 298, if we can move on to that. And what at 298 line 5, this is the last couple of references, what they are saying, my question at 5, is that's what they're saying. They are saying relevance is the key element or touchstone of whether internal documents are required to be provided pursuant to the duty of account. Well, they say that, yes. Firstly, they say relevance would be a little bit different on how I read it because they don't use the word relevance but necessity in connection with internal documents. What they do not do, and they don't do it for a reason, they don't refer to purely internal documents. So this is the point relied on by Professor Pishinaz as saying the most recent decision in 2019, this reference to purely internal documents has gone. That is exactly my point. And then on the next page, 299 at line 5, you see if you are right and there is this extra category of relevant purely internal documents, then there is no principle in relation to the duty to account, is there? There's no principle which the courts are applying. It's just you're entitled to some of the documents which may be needed in order you can get some of the information which may be needed to hold the agent to account. That's what you're saying, isn't it? Well, the decision 139, that's the 2012 decision, didn't come into a landscape where nothing existed. There is a core practice of more than 30 years, and the issue is always necessity. If you want to call it relevance, make a big point of it, I don't think it's that, but you have to account for what you did. That is the principle. You have to account for what you exercised. Now, I have to say, so those are the passages I wanted to draw your attention to. I have to say it is completely unclear what Dr. de la Fière actually was saying. He started off by saying, doesn't matter how important the document is, if it is purely internal document, you can't have it under Swiss law. He then appears to contradict that and says, if it's necessary, then you do have to disclose it, drawing some distinction he hadn't just drawn before between relevance and necessity. He then goes back at one stage to say, yes, it is necessity, but subject to purely internal documents. And then at the end, he seems to accept the necessity principle. He is unable to give any content to what is meant by a purely internal document, other than to say you decide it on a case-by-case basis. Now, in the light of that, I would suggest it was not entirely surprising that the Chief Justice, having heard Professor Pichina's rendition and explanation of this in lucid and clear and unequivocal terms, took the view that Professor Pichina's interpretation was correct and Dr. de la Fior's was not. And no doubt that is why he refused leave to appeal in respect of this point, as this is very much a question of fact, which is entirely in my submission, unless the court can point to some error on the part of the Chief Justice in his analysis. It is a matter where he obviously had an advantage over this court in relation to that. So I think those are my submissions on Swiss law. And I think, unless there's anything further I can assist the court with, really that's it.
Yes. Well, I wonder whether that might be a convenient moment to take a 10-minute break.
Well, yes.
Right. We'll go into a separate room.
I just asked the parties who are online here to make sure that you turn your mics off and your cameras when we take the adjournment. All right, is Mr. Moverley Smith still with us?
Yes, I am.
Okay.
Thank you.
So Christopher, can you hear us?
Yes, can you hear me?
Yeah, I can hear you now. It looked as though you were talking, but I didn't hear you.
That's because I wasn't talking.
Yeah.
Right. Well, Mr. Moverley Smith, any reply?
Yes, I'll be brief if I maybe.
Yes.
I think in relation to jurisdiction, I've made all the points I need to make about that. You've got my submissions. And whilst we don't accept Mr. Hollander's characterization of what happened and what the evidence was, I don't think any purpose is going to be served now by providing alternative views of what occurred.
Mm-hmm.
So you essentially we're back to the question about what you can do with Order 24 Rule 7.
Yes.
I said, clearly I need to revisit that. In terms of waiver, the cases I referred to remain good law. No one's suggesting the cases in the 1980s have got the principle wrong. The later cases don't suggest they are wrong. They develop the principle and explore it in different contexts. But the underlying analysis that you see in the early cases is one that's carried through. Right back to the case of the Master of the Rolls in 1938. It's the same approach. And clearly you're looking at the effect of a document. The effect of a document we are describing is making a request. The document is a request for specific documents. That's its effect. It's received by the bank send the documents pursuant to the request. And that doesn't mean we're referring to the substance of the letter, the contents of the letter, or quoting verbatim from it. And you'll recall the observations of Lord Justice Lloyd that we looked at earlier, where he said, unless there was, clearly was saying, unless there was a verbatim or something akin to a verbatim reference, it wasn't sufficient. The later cases that I took you to, including the one of last month, are all consistent in that they adopt a benevolent approach towards waiver. They won't find that waiver has occurred unless the position is obvious.
Right.
And my learned friend didn't take you to really any passages at all that really explained away the very clear approach adopted in those earlier cases in the 1980s. In terms of the law being uncertain, it is relatively straightforward in terms of understanding where a waiver will occur. The question really is, how far do you need to go by reference to the contents of a document before a waiver is effected? And it's clearly a reference to the contents in some detail before you get to that point. As you can see by those cases involving the Japanese law advice, for instance, or the advice from the Iranian lawyers. In both those cases, there was a reference to what the document was about or what the advice was about. But that wasn't considered to be a reference to the contents. It was as to the effect of the document in question. And so I think all we really say is go back to those earlier cases. They do reflect the law. And if you apply an analogy by reference to those cases, you get nowhere near a waiver.
Yes.
In terms of
Could I just ask you one point on that? There was an express reservation of privilege. Does that add to the mix?
Well, in terms of whether or not a waiver was intended, so to
Yeah.
the extent you look at the intention of the parties, it plainly wasn't intended that there should be any waiver. And if you look at the early cases, in terms of deploying evidence or referring to a document subject to privilege in pleadings, in the early cases, they seem to suggest that you have the opportunity being put to your election as to whether or not you waive privilege and continue to rely on the information, or whether you would withdraw the material. And essentially what we were saying here was that we were not intending in any way, shape or form to be waiving privilege and making reference to the effect of the relevant documents.
Yeah.
A rather curious consequence arises, it occurs to me, from Mr. Hollander's submissions, because he says there's a distinction between saying we wrote to the bank, for instance, and saying we wrote for the bank requesting the documents referred to in your long letter of whatever. But that would lead to the following rather curious position. Let us assume that there is a complaint that the disclosure is inadequate. The party who is said to have failed to give adequate disclosure writes to, for instance, in this case, the bank, and writes to the solicitors on the other side saying, we've written to the bank. That's inevitably going to produce a response. I'm sure you've written to the bank, but simply telling us that you've written to the bank is uninformative. What did you write to the bank about? Have you asked them for the documents that we asked you for in the letter which we wrote to you? And apparently, if the response is, yes, we did, that becomes a waiver of privilege.
Which would be a curious result.
Yes, it would.
And
the right result, but...
I think that rather provides the answer to the question, because if simply by that chain of correspondence, the cumulative effect is to waive privilege, it becomes almost impossible to respond in relation to any aspect of litigation. I mean, the example being given in the authorities about an Order 14 application, where you say you advise you've got no defence to the, there's no defence to the action. And the immediate consequence of Mr. Hollander's analysis would be that you would need to produce the advice that told you that there was no defence to the action. That was the example given and said to be an absurd example, because plainly that could never be the position. And that's exactly the position here. And exactly why those other cases involving the Japanese advice and the Iranian advice were decided the way they were. And as I say, the court does adopt a benevolent approach and doesn't assume a waiver of privilege lightly. So to the extent there's any doubt, it should be erring on the side of upholding a privilege.
Right.
So that's what I wanted to say about privilege, unless there's anything further I can assist on that. In relation to Swiss law, the analysis of Mr. Hollander of Dr. Dalifor's cross-examination in our respectful submission was entirely unfair. When you look at it, clearly what he was saying was that in relation to internal documents, they need to be produced if necessary, but carved out of that obligation is the fact that documents that are purely internal are excluded therefrom. And you can see that all the way through. So when he's asked about internal documents, he says where it's necessary to see those documents, then they're to be provided. But he says that in the context of having already made the point that carved out of that are purely internal documents. And so to do the cherry picking that only friend did of his cross-examination just doesn't do justice to the answers he was giving. And in our respectful submission, if you look at the whole of his evidence, he's completely clear as to the legal principle. The position in relation to...
I'm sorry, I'm so sorry, I haven't quite understood the proposition you've just advanced. You said, or at least my note of what you said, is that what he was saying was that internal documents are to be produced if necessary, but purely internal documents are excluded.
Yes.
That seems to be the proposition, that internal documents are to be produced if necessary, but purely internal documents are excluded even if they are necessary.
Yes. So essentially you have a general category of internal documents that are required to be produced if necessary. Within that category is a sphere of protected documents which don't need to be produced.
Even though they're necessary.
Even though they're necessary. In the same way that you could say that documents subject to legal professional privilege may well be relevant and otherwise necessary, but they're not something you can look at. It's that sort of situation he's describing.
But that's a very odd result, because the principle behind it all is to assure the accountability of the agent. And yet there is a class of documents which are documents that are necessary in order to see whether or not the agent has done what he should have done, but carved out of documents which are necessary for that purpose is a subset of documents which, although necessary, are to be characterized as purely internal.
Yes.
If the whole idea, yes, but if the whole idea is that the principal gets an account of what the agent had done, what is the rationale for such an exclusion from the documentation which is necessary for that purpose?
Well, I think one needs to look back at the history. So the duty to account under the code has been around for a long time. Prior to 2012, even though it might be necessary for the purposes of the account to produce internal documents, there was no obligation to do so, because they were viewed as being part of a protected category and therefore not subject to any duty to produce. In 2012, the Supreme Court moved in the sense that it then suggested and then provided that internal documents were subject to the duty of account and should be produced, but didn't go the full way of saying everything must be produced. It maintained a category of documents that still was subject to the protection that all the internal documents had been subject to prior to 2012. And that reflects the general unwillingness of Swiss entities and Swiss courts to provide information. It's a country noted for its secrecy, noted for its unhelpful approach, it might be put that way, in relation to the disclosure of documents. And this is consistent with that theory. And if you look at what Dr. Dalifort says about it, it's exactly that this is the approach the court has taken. It had moved a bit, but not as far as to say everything that's relevant is disclosable. And that's why you have the excluded category.
I see, okay.
I think the other point is what was the standing of the witnesses, and was this a case where the judge was taking an adverse view of Dr. Dalifort's credentials and abilities? He makes no comment at all about either witness, so there's no comment as to the credibility or otherwise of what they say. In terms of Professor Pichonas, it might be worth just looking at page 262 of the transcript. So this is tab 19 again, at 262 to 263. And you'll see I put to him that at the end of the day, it was simply his opinion, his own view of the judgment. There's nothing beyond the judgment that the court could look to obtain any assistance in relation to what was meant in the 2012 decision. And he said yes, subject to the 2019 decision, which we've seen.
So in which passage are you looking at page?
So I'm looking, yes, I'm sorry, I wasn't very clear. On page 262 at line 20, at line 18,
Yes.
I pick him up because he says that the category of purely internal documents was essentially documents that were irrelevant or trivial. I pick him up on that point at paragraph 18, and he sort of backs down on triviality and says, well, that's a question of language perhaps. And then I make the point at paragraph 29 that at the end of the day, all you have is your interpretation of a judgment and nothing beyond that, which is what I'm saying on the top of the next page. And he agrees with that, subject, he says, to the 2019 case which we've seen. So it's not as if there's a whole body of authorities that he's analysed to get to the result that he got to. He's simply expressing a view by reference to the language of
I'm so sorry, I still haven't got what you're looking at. I'm looking at page 262.
Yes, right at the bottom of 262.
Yeah, but at the end of the day, though, what you have from the Supreme Court is what is said here. Yes.
And then it's the point you wouldn't be really able to point to anything beyond this case in your own view of this case to support your argument. It's that point.
Okay.
Yes.
Yes.
Sorry, maybe it wasn't as clear as it should have been.
All right. Okay, I follow.
So my point is, in terms of what the judge was weighing up, he's weighing up simply a view expressed without support of any other material as to the meaning of the 2012 decision. And he also accepted that there was no change. So the 2019 decision, in his view, wasn't a change from 2012, was no change. And so therefore the 2017 decision, similarly, must have reflected the way the tribunal was interpreting the 2012 decision, or how it recorded the 2012 decision. So if there's no change, the 2017 decision is as valid as the 2019 decision in determining what they meant in 2012.
What happens if the interpretation in the 2017 decision was one way and the 2019 was the other?
Well, the 2019 wasn't necessarily the other, because all it says, if one looks at that, maybe it is worth just having a very quick glance back at it. Sorry, put it away. The 2019 decision, which is tab 8, page bundle 6, tab 6, sorry, volume 6, tab 8. And this was a case, I think I took you to the introduction at pages 67 and 68 with capital A, little a, and then capital A, little b. And the fact that this was an heir trying to establish what had happened to his late mother's money, the account had been paid into. And that you can see what was being requested on page 68 were the instructions given by the deceased in relation to the management of the accounts.
Yes.
So nothing at all to do with purely internal documents or internal documents, or any distinction between the two. And then you turn over to paragraph 4.2.2.1 on page 70.
Yes.
And here they're talking in general terms about the agent's obligation. Regarding the agent's obligation in general, case law accepts that the obligation to account for his management includes the obligation to inform, and so on. So he's talking in very general terms. And at the bottom, he simply says the duty to provide information may also relate to the content of internal documents, provided that it is relevant for monitoring the activities of the agent. And of course, that's entirely right and entirely consistent with what was said before, because what was said in 2012 was that you now can look at internal documents, of course, subject to the carve-out. There was no reference to the carve-out here because it wasn't a relevant consideration. We're talking in general terms, as they say in the first line of 4.2.2.1, and simply saying, in general terms, you can have internal documents. The issue of purely internal documents simply didn't arise, in other words.
Right.
I think beyond that, unless there's any further point I can assist with in relation to any of those three matters, those are my submissions.
Thank you very much. I don't know whether either of my colleagues has a question.
No, thank you.
Thank you.
Right. Well, it may not entirely surprise you that we will take some time to consider our decision, but we are most grateful to the parties for their submissions, both written and oral, and for participating in this rather unusual way in the third remote hearing of this court. Thank you all very much.
Thank you.
We'll retire to our room.
Thank you very much.
So that's a good thing.
Yeah.
Well, we were sure. It did sound like they were coming back, but